to start with having counsel put their appearance on the record. Mr. Reichel, let's start with you and then we'll go to Mr. Bach.
Good afternoon, Your Honor. Assistant Attorney General Robert Reichel, appearing on behalf of Attorney General Nessel.
Mr. Bach.
Yes, thank you, Your Honor. Assistant Attorney General Dan Bach, appearing on behalf of the Attorney General.
Mr. Ellsworth, let's go to you, sir.
Good afternoon, Your Honor. Peter Ellsworth on behalf of Enbridge.
Mr. Coburn.
Good afternoon, Your Honor. David Coburn with Steptoe and Johnson on behalf of the Enbridge defendants.
And Mr. Hassler.
Good afternoon, Your Honor. Bill Hassler on behalf of Enbridge, appearing pro hoc vice. Is there a feedback problem, Your Honor? I can go to another room if there is.
I do not hear any at this point. Ms. Dexter, are you okay?
Okay now.
Okay. We'll let you know, Mr. Hassler.
Thank you, Your Honor.
As I indicated, this is the time for a hearing on plaintiff's motion for preliminary injunction following issuance of a temporary restraining order. The parties have fully briefed both with regard to the temporary restraining order before it was issued and then subsequent filings in connection with the preliminary injunction request. I have before me, with regard to this particular hearing, plaintiff's motion for preliminary injunction, defendant's response in opposition to plaintiff's motion for preliminary injunction, and plaintiff's reply in support of motion for preliminary injunction, along with a host of additional documents submitted in connection with all of those pleadings, some contemporaneously with those pleadings, and some that have been submitted thereafter, including very recently. I have had an opportunity to review all of that you have submitted. We also had three groups of parties, not parties to the lawsuit, but three groups that had requested permission to file friend of the court briefs. That was granted by me this morning. An order was issued. Hopefully all of you have received that order as well. As we go along, if you refer to a document that I don't think I have, I'll let you know that. But as far as I know, everything that has come through to the court by way of your email submissions, primarily keeping Ms. Smith informed as you went along, I have received. So I also know that there is a supplemental or demonstrative that I believe Mr. Ellsworth, or at least the Enbridge side, intends to use. I do have that. That was emailed as well. I have that. I know that Mr. Ellsworth or whoever is going to address that part of it may choose to also show that by way of screen sharing, which is a capability of Zoom. But if it doesn't happen in that way, Mr. Ellsworth or whoever else plans to utilize it, I do have a copy right here as well as the email with the version of it on it. What I intend to do is to let each of you go through your arguments first to present your position with regard to the preliminary injunction motion. I'll do my best to try to refrain from interrupting you as we go along so that you can make your complete argument. And then my intention is to ask some questions that I have. My hope is that through your presentation, if I do a good job of not interrupting you too much, I'm hoping that many of the questions that I noted as I went through all of these documents will in some way be answered. I may cover some of that ground again in some of my questions, but that's my plan, at least at this point in time. Fair enough for everyone?
Yes, Your Honor.
Shaking of the head, yes.
Judge,
Yes.
I'm sorry. I need to be able to confirm that we've got volume on the live stream. If you could hold just for a moment.
Will do.
And can I ask anybody who is not speaking to go ahead and mute yourself? And then if we could do that, we'll have no feedback issues.
How do you do that?
There should be There's like 3 little dots and you click on that and there's a pull down menu and you should be able to mute yourself.
On the screen where you see yourself, Mr. Ellsworth,
Yes.
there should be an area, if you go up to the right-hand corner with your cursor,
Okay.
usually an area that comes up as mute and
Mute.
unmute. And if you don't see it, there are 3 dots that you can click on that may give you the button option. Do you see that up there?
I see 3 colored dots on the left side of the screen.
How about at the
I
bottom?
think I can get you, Mr. Ellsworth. We do
Okay.
have volume on YouTube. I have confirmed.
Okay, very good. All right. So Ms. Smith has you muted at this point, Mr. Ellsworth, and when you're ready to speak, we will make sure she lets that mute button off there. Mr. Reichel, I assume you are going to present the primary argument on behalf of the state. Is that correct, sir?
Yes, that is correct.
All right. Are you ready to proceed?
Yes, I am.
Go right ahead with your motion, sir.
Thank you, Judge. At the outset, before addressing the merits of the motion for preliminary injunction, I would like to express the Attorney General's appreciation for the court's very prompt and thoughtful consideration of our motion for temporary restraining order and its recognition in its order that underlying this case, and indeed relevant to this motion, there is a serious risk of harm, not only to natural resources, but to many communities, that endangers or potentially endangers the livelihood of many people and businesses, as well as the natural resources. So with that said, I'd like to turn now to the substance of the issue before the court this morning, which, as you well understand, is our motion for preliminary injunction, this afternoon. Again, as the court knows, there are 2 elements of our motion for preliminary injunction, 2 forms of relief that we are seeking. The first has to do with information. In our motion, we ask that the court order the Enbridge defendants to immediately provide any and all information in their possession, including underlying data, engineering reports, photographs, videos, etc., that relate to the recently discovered conditions on both the east and west pipelines of the Straits pipelines. And the second, and that relief is requested, as the court has already noted, with regard to the temporary restraining order, on 2 bases. One is the obligations that Enbridge voluntarily assumed contractually under the 1953 easement that it entered into with the state in order to obtain the right to construct and operate those pipelines. The second, an independent source of the basis on which we request the court to order the disclosure of information is the October 2018 so-called second agreement between the state of Michigan and Enbridge, which, among other things, in which Enbridge agreed to provide information requested by the state relating to the operation of the pipeline. The second element of the injunctive relief that we are seeking, and this one being based solely on the obligations and responsibilities contractually assumed by Enbridge under the 1953 easement, is to continue temporarily, not indefinitely as Enbridge has suggested, but continue temporarily the suspension of operations on both the east and west pipelines until A, Enbridge provides, and the state has had an opportunity to review, all the requested information, and B, that Enbridge affirmatively demonstrates that as it relates to the recently discovered impacts to the pipelines, both east and west, that it would be reasonably prudent to resume operation. And again, as the court recognizes and noted in its TRO, the 1953 easement has a specific obligation, and a very broad one, imposed on Enbridge, that at all times to exercise the due care of a reasonably prudent person with respect to its operations on Line 5. Before turning to the merits of those motions, I'd like to address at the outset the relationship between the present motion for preliminary injunction and the underlying claims pled in our complaint. The court will have observed that Enbridge has suggested that somehow the position we are advancing in these motions is in legal conflict with and cannot be reconciled with our underlying claims in our complaint. Again, as the court is well aware, our underlying complaint alleges on various grounds that the 1953 easement was invalid and or that the continued operations pursuant to that easement would conflict with other Michigan law, including the common law public trust doctrine, the Michigan Environmental Protection Act, and the common law public nuisance. Again, as the court is well aware, there are currently pending before Your Honor cross motions for summary disposition with respect to the legal bases of those claims. And again, as you know, supplemental briefing was allowed by the court. Enbridge has filed its supplemental brief. We will be filing our supplemental brief addressing those legal issues, which include, by the way, preemption in the very near future. But I mentioned this just to dispel the notion that somehow by invoking the 1953 easement as a basis for preliminary injunctive relief, we are taking a position inconsistent with our underlying claims. The state of the play at this point, Your Honor, is that while we have alleged, as I've said, among other things, that the easement is invalid or should be determined to be invalid once the court reaches the merits of our underlying complaint, the simple fact of the matter is that has not yet occurred. And so the status quo is that the easement is in effect, and we submit Enbridge is bound by it. And until the court determines, or some other court finally determines, that the easement is invalid or should no longer be applied, it is in effect. And while Enbridge operates the pipelines, it is bound by its terms. So again, we see, despite Enbridge's suggestion to the contrary, no conflict between those two things. Again, the court has obviously read the briefs, but just quickly highlight what I plan to do in my argument, as I'd like to address each aspect of our request for preliminary injunctive relief in terms of the four factors that case law clearly establishes, and the parties don't disagree on, that this court must consider in weighing a request for a preliminary injunction. Those are, of course, number one, the plaintiff's showing of likelihood of success on the merits. Number two, the harm that the plaintiff will incur in the absence of the requested injunction. Number three, the harm, if any, that the defendant would incur or suffer if the injunction is granted. And number four, the impact of the requested injunction, if issued, on the public interest. So with that background, let me turn to the first prong of our request for injunctive relief. That is the request for all available information relating to these recently disclosed instances of impacts to the pipeline. With regard to likelihood of success, again, as we've explained in our brief and I've just alluded to here, we believe that if one looks both at the 1953 easement and the subsequent 2018 second agreement, we have stated a clear and meritorious basis for the court to grant the requested relief. That is requiring Enbridge to fully disclose the information that it has. And it's not clear to me whether Enbridge is even contesting that legal basis, but in any event, unless the court has questions about that in future, I will leave that prong of the likelihood of success there. Now, with respect to the factual matter of whether such an injunction is necessary, I anticipate that Enbridge will argue, among other things, that they provided a great deal of information to the state, and as the court has noted, to the court as well, relating to the circumstances that prompted the temporary shutdown of both pipelines on June 18th, and essentially brings us here today. We don't dispute that. And indeed, we've acknowledged in our reply to Enbridge's motion that, our reply to their opposition, that a variety of documents have been provided, as well as extensive video footage taken by remotely operated vehicles that Enbridge had its contractors deploy to take pictures essentially of along each of the pipelines, including, among other things, footage of the areas of interest, as the engineers would call it, that bring us here today. But from our perspective, and as we've explained in our reply, that disclosure, while extensive, is not complete. The state had a pipeline engineer who works for the Michigan Public Service Commission on issues involving regulation of natural gas pipelines, but pipelines in a broad sense are pipelines. And he certainly has indicated, his name is Nathan Miller. We've submitted an affidavit from him in support of our reply. We believe, for the reasons that he stated in that affidavit, that notwithstanding Enbridge's production of a good deal of information, and again, this is not a discovery motion has been suggested, we're simply trying to exercise the state's contractual right to obtain this information on the basis that I described. So Mr. Miller's affidavit notes a couple of things. First, with respect to some of the technical information that Enbridge provided to support its conclusion that it could prudently restart the West Line, and for that matter, its evaluation of the East Line. Part of the technical analyses by the Enbridge engineers looked for correlations between the observations of the exterior of the pipeline and some pre-existing data or measurements that have been taken by the pipeline. And those include what are called inline inspection or ILI data. And again, at the risk of grossly oversimplifying it, Enbridge, like other pipeline operators, frequently deploy instruments, so-called ILI inspection tubes, that are essentially inserted into the pipeline, carried through the pipeline with the movement of product through the pipeline, and then, depending on the type of instrument involved, are able to remotely measure various conditions within the pipeline. So, for example, they can detect changes in the shape of the pipeline. If it's going out of round, it's more oval. If there are cracks that are present, it can take measurements that would enable people reviewing it to infer if there's been a loss of thickness in the pipeline, things of that nature. So Enbridge's analyses suggested that they have looked at those kinds of historic data, or so-called ILI data, compared it to the conditions that exist or observed on the surface of each pipeline. And that's part of the basis for their conclusion that they don't believe there is a problem that merits either repair or shutdown, for example, of the West Line. As I understand it, Enbridge itself is still in the process of reviewing information with regard to the East Pipeline, and I'll address that more later. A second, and frankly, much more fundamental issue that was flagged in Mr. Miller's affidavit is that despite our request to provide information regarding the cause, not only the nature and extent of the conditions observed on the pipelines, but the causes of them. Now, Enbridge's analyses have, particularly in the affidavit of Mr. Maxwell, identified certain hypotheses as to what it might happen in both areas, both on the East and West pipelines. But as of today, they have not yet determined or explained how these conditions occurred. How it was that some external object, Enbridge hypothesizes in the case of the West Line, that it was a cable of some kind, presumably trailing from a vessel, that dragged across a lake bed, hit the West Pipeline, and was carried across it. In the course of doing so, at a minimum, disturbing some biota or quagga mussels that are endemic in the Straits and currently coat much of the pipeline. With respect to the other one, that is the East Line, Enbridge's engineers hypothesized that some sort of object, whether it was an anchor, possibly an anchor deployed by, quote, a medium-sized vessel, was carried along the lake bed in the vicinity of the pipeline, not necessarily on lake bed, I don't think they said that, was carried along longitudinally in the same direction as the east pipeline and impacted the so-called anchor support structure at that designation, which the engineers refer to as, I believe, EL 71, 7-1. In any event, they've hypothesized about it, but there has been no determination of the cause. And even more remarkably, there's been no determination of when these events that gave rise to these conditions occurred. Indeed, there's no evidence that Enbridge currently has in place systems that have the capacity to detect when they occur impacts by foreign objects on the pipelines, which, needless to say, from the state's perspective, is extremely concerning. So, to summarize, from our perspective, as a factual matter, there are still other pieces of very important information that have not yet been provided. That is why we submit that there's not only a legal basis, but a factual basis for directing Enbridge to more disclose information on the subjects that we have identified, including particularly the issue of causation, as well as what measures have been or will be put in place to detect and prevent similar occurrences in the future. With regard to the other factors, harm to the plaintiff, I think the court's analysis in its TRO request correctly noted that there is inherent harm to the state in the absence of the information that Enbridge is contractually obligated to provide. Because without full information, the state cannot exercise the duty that the court recognized it has to protect the public trust and to ensure compliance with the agreement that the 1953 easement, so long as it is in effect. With regard to the remaining prongs, that is harm to the defendant, Enbridge, if that relief is requested, to the best of my knowledge in the voluminous papers that have been filed here, Enbridge has not even attempted to assert that it would be harmed if it is required to further disclose information on these subjects. In any event, it is difficult to imagine what that harm would be other than perhaps the expense of doing so. But I respectfully submit that whatever additional expense might be entailed in that would be outweighed by the harm to the state in the absence of being able to obtain and review comprehensive information. Finally, with respect to public interest prong, again, I respectfully submit that the public interest manifestly would be served if, as our motion requests, all the available and relevant information is provided to the state so that it could exercise its independent responsibility under the easement to ensure that the pipeline is in fact being operated consistent with Enbridge's due care obligations, and that there would not be harm to the public trust rights if that happens. Again, all of this, I want to emphasize, is with respect to the particular conditions or incidents that were recently discovered. And I'll turn to that in a moment. But when we talk about the second prong of our request for injunctive relief. So to summarize, Your Honor, I think all of the factors that you are required to consider with regard to preliminary injunction support our request for additional information. Let's turn now to what I know is obviously the much more contentious issue before the court today. That being that portion of our request for a preliminary injunction that seeks to extend temporarily, not indefinitely or for weeks, as Enbridge suggests, the condition of suspending the operation of the pipelines. As a factual matter, let's just touch on that. As the court itself noted, the East Pipeline, Enbridge has not attempted to restart it since the June 18th event. It's my understanding from looking at their own papers and that they've supplied to the court that their own engineers are doing further evaluation of the circumstances there. Although it remains unclear, and I assume Enbridge's counsel will apprise the court on what they propose to do about that. One other important piece of information that was provided to the court and the plaintiff quite recently, i.e. about 24 hours ago, was correspondence. And by the way, this is the first and only copy of written correspondence from the Federal Pipeline Hazardous Materials Safety Administration, or PHMSA, to Enbridge that documents communications back and forth between that agency and Enbridge. Again, I'm sure the court has had a chance to look at it, but the risk of oversimplifying it as it relates to the East Pipeline, PHMSA stated that it was conducting its own investigation of the incident that gave rise to the anchor support damage. And it then propounded a series, requested information on, I believe, 20 separate discrete technical subjects that requested Enbridge to provide, and specified a time frame for doing so, which I believe in one instance was 15 days and the other 30 days. But I don't have the exact language before me, but it's fairly clear from what PHMSA communicated to Enbridge as it relates to the East Line. Its view is that the East Line operation should not resume at this time until these other information are made available. So as a practical matter, I don't see any legal basis why Enbridge would oppose an extension of, excuse me, it's not an extension of the TRO, but essentially a preliminary injunction that extends the prohibition, the temporary prohibition of operating the East Line under these circumstances. Certainly, at least until the information that PHMSA itself has insisted that Enbridge has been provided to them, and we submitted should also be provided to the state so that we can each review it. So again, the most contentious issue clearly today is our request for a continuation of the suspension of operation of the West Line. Now, on that subject, the Enbridge's initial position and their opposition or response to our motion was that they had communicated with PHMSA, I believe, on the 19th of June, and then again on the 20th of June, and that in essence, PHMSA said that based upon the assurances provided by Enbridge, PHMSA had, quote, no objection to resuming the operation. The most recent correspondence dated June 29th from PHMSA to Enbridge that was provided to you yesterday and to us does briefly touch on the West Line. And again, in a similar fashion, it indicates that at this time, based upon available information, PHMSA has no, quote, technical or safety objection to resuming operation of the West Line. Where that leaves us then is, we stand by our position in our request for preliminary injunction on this prong, that two conditions need to be satisfied before Enbridge should be allowed to resume operation of the West Line. And again, those are full and complete disclosure of information relevant to that, including the issue of causation, and two, an affirmative demonstration by Enbridge to this court that as it relates to this recent incident that involving an impact of some kind to the West Line, it would be reasonably prudent to resume operation of that West Pipeline, or West Leg as it's sometimes referred to. And this all in the context of the focus from our perspective on this particular incident or recent incidents. The other issue, the underlying issues raised by our complaint is whether it would be reasonably prudent or even lawful to continue to operate the pipelines indefinitely. But again, that issue of permanent closure is not before this court. I want to emphasize that very much, particularly in light of the voluminous communications that Enbridge has provided to the court, in addition to the amicus briefs that the court has noted, Enbridge filed a series of letters addressed to the court by various Enbridge customers, presumably as a result of some sort of letter writing campaign that Enbridge initiated to talk about their concerns regarding the impact of a shutdown on their operations. I'll turn to that more later, but the other, going back to the factors that this court has to consider, again, we believe that with respect to the issue of likelihood of success in the merits, we have stated a legally solid basis for granting that relief based upon the terms of the 1953 easement. Now, Enbridge has argued, and will undoubtedly argue when they have their turn here in a few minutes, on various grounds that that relief is not available. Most notably, their contention that federal regulation of interstate pipelines under the Pipeline Safety Act, carried out by PHMSA, preempts or legally precludes the state from seeking or from this court granting the injunctive relief we've just discussed, which is a temporary cessation of the operation of the pipelines. We've addressed that in our brief, but I'd briefly like to highlight the crux of our position on this. The federal statute involved, the Pipeline Safety Act, precludes states from adopting pipeline safety standards, the kinds of standards that, as Enbridge notes, are included within PHMSA regulations promulgated under the Pipeline Safety Act, which address a myriad of technical and other issues relating both to pipeline design, operation, monitoring, etc. What the state is seeking here in this context is not attempting to prescribe some Michigan-specific or conflicting safety standard that would prescribe particular details as to how the pipeline would be operated that are governed by PHMSA regulations, but something simpler and distinct. That is, ensuring that Enbridge has met or will continue demonstrating that it can meet its contractual obligation under the 1953 easement to exercise the due care of a reasonably prudent person with respect to the operation of the pipeline. And again, we've touched on this in our brief, the issue of preemption. In the interest of time and space, we didn't extensively brief it in our, reply brief filed yesterday. But as we briefly highlighted, this is, as I just said, not the imposition of a Michigan-specific safety standard, but rather the enforcement of an existing, indeed pre-existing contractual obligation that Enbridge committed itself to long before the Pipeline Safety Act existed or PHMSA existed. The other relevant, in addition to our point that the cases that Enbridge principally relies on in its opposition are, we think, certainly not legally controlling, nor do we believe the court should find them persuasive. They also, I just want to briefly touch on another point that they allude to in their papers as an additional support for their preemption argument, which again, in the interest of time and space, we did not have the opportunity to yet fully brief, and that is, but I assure you, we will be briefing in our supplemental brief on the cross motions for summary disposition, and that is their suggestion that a federal statute, the Federal Submerged Lands Act, somehow controls the situation. Very briefly, Enbridge argues that the Federal Submerged Land Act, which coincidentally was adopted in 1953, it was by virtue of that act the state of Michigan obtained title to the bottomlands at issue. Again, we will brief this further in our supplemental brief on the cross motions, but that simply is flatly untrue. Michigan, like every other state that entered the Union, in our case in 1837, under the so-called equal footing doctrine, obtained title to bottom lands on navigable waters. And that is not by statute, it's by operation of the Constitution itself. And so it is the case that Michigan didn't obtain title to the bottomlands at issue by virtue of the federal statute that Enbridge cites, but rather by virtue of the Constitution. Now, courts have recognized and still recognize that under the constitutional framework, the grant of title to the bottomlands was subject to certain federal interests, most notably what's referred to as the federal navigational servitude. And again, I can give you some cases on that, but I just, the basic principle, and it's not widely disputed, I think, is that while the Constitution gives the states, when they entered the Union, title to bottomlands in navigable waters, the federal government retains the right to control and promote navigation in those waters. Of course, here we are not talking about, the pipelines have nothing to do with navigation. So again, we will brief this further, and I can supply further authority if the court likes, but on that subject, let me just briefly refer to, excuse me, the cases of Oregon versus Corvallis Sand and Gravel. It's 429 U.S. 363, 1977, which explained the principle that I've just discussed, which is that the Constitution conferred title to bottomlands of navigable waters when under the equal footing doctrine, and that other cases discussed in that case, including Gibbons versus United States, 166 U.S. 269, 1897, recognized this other principle that I alluded to, that is, though the states have title to the bottomlands of navigable waters, that is subject to the so-called federal navigational servitude. Again, I don't want to belabor that further, but the salient point that I want to make is that contrary to Enbridge's suggestion, we don't believe that either the Pipeline Safety Act or somehow the Federal Submerged Lands Act has the effect of precluding or preempting the state from seeking to enforce, as it's doing here, its contractual rights against Enbridge under the 1953 easement. And for similar reasons, Enbridge's other main argument, which is tethered in the Commerce Clause of the US Constitution, which again, and we don't dispute this, confers upon Congress the right to regulate both interstate and foreign commerce. But as we point out, what the relief requested in this motion is not in any way, shape, or form an attempt to assume authority to, quote, regulate commerce either between the states or with foreign governments, or to undermine the federal government's ability to, quote, speak with one voice as it relates to foreign commerce or relations with foreign governments. What we are seeking is simply the enforcement of obligations that Enbridge assumed under what is essentially a real estate contract applying to a particular piece of state-owned bottomlands that Enbridge voluntarily entered into in 1953, and we submit is still bound by. So for those reasons, we believe that we have shown and can show a likelihood of success on the merits. With regard to the other factors, again, harm to the plaintiff, the state in this case, in the absence of that requested relief, again, I would echo my previous observation, indeed this court's observation itself in the TRO, that the state has the right to obtain information from Enbridge, not only information, but in this case, in this part in particular, to assure that Enbridge is meeting its obligation to at all times exercise the due care of a reasonably prudent person. The issue of harm to Enbridge and other parties, let me touch on in this way. Enbridge, of course, and not surprisingly, suggests that even a temporary cessation of operations on the pipeline causes it to lose revenue. I believe in one of their filings, they suggested something on the order of $1.76 million per day. And I don't mean to make light of this. Even for Enbridge, I assume that's a significant amount of money. And the other point that Enbridge and its supporting amici stress, as well as the letter writers that they had write to you or they provided to the court, similarly emphasize their concern that shutting down the pipelines will cause significant economic harm, for example, to refinery operators or other customers who depend upon their products. Without getting into the detail of that, while we don't, I don't dispute that continuing the suspension of operation will cause or could result in some economic harm to Enbridge itself and its customers. But I think the thing to keep in mind is, in this context, that I think is very important, is that we are not, as Enbridge suggests, asking this court to order them to indefinitely or for an extended period of time keep not only the East Line shut down, which I presume they're going to continue to do for the reasons I mentioned earlier, but also the West Line. It would be, under the scenario that we believe would apply here, a matter of days, certainly not several weeks. Again, the trigger as we see it, or not as we see it, but what we are asking is that this temporary suspension of operation continue only so long as is needed to A, provide the requested information, and B, to affirmatively show that as it relates to this recent incident or recently discovered incident, that it would be reasonably prudent to resume operation, again, pending the resolution of the underlying case. And then finally, with respect to the public interest prong, as we noted in our brief, the public interest, both in the Michigan Constitution and statute, strongly and appropriately reflects the public interest in protection of the environment, preservation of the Great Lakes associated resource, and the protection of those resources from harm is a very substantial, indeed we would suggest paramount interest of the state. So I submit, Your Honor, that what we're looking at here, if you consider all of the factors, including the balance of harm and the impact on the public interest, that a limited extension of the shutdown of the West Line is both appropriate and warranted. So in conclusion, just to reiterate that the relief we're asking for today is, one, an order directing Enbridge to provide to the state and to this court, for that matter, all the available information that we have been seeking, not only the underlying technical detail that supports its engineers' conclusions, but more importantly, a substantive determination of what happened, what caused this, and how it can and will be prevented from recurring. And then secondly, to have Enbridge affirmatively show before it shuts down, before it resumes operation of the West Line, that it is reasonably prudent to do so, consistent with its obligation of due care under the 1953 easement. I think that covers the main points I wanted to in my initial presentation, Your Honor, since you indicated that you proposed to, and I'm certainly fine with this, to reserve your questions until after all counsel have spoken. That I'll be happy to address at whatever point any questions you may have. And not surprisingly, I would request the opportunity, which I'm confident the court would provide, to to respond to the presentation by Enbridge's counsel. Thank you.
Certainly, Mr. Reichel. All right, thank you, Mr. Reichel. Mr. Ellsworth, will you be making the presentation on behalf of Enbridge to start at least? Casey, unmute.
Your Honor, am I on mute or am I?
We can hear you, sir.
Okay, with your permission, Your Honor, we would like to divide our argument as follows. Mr. Coburn would start by providing an overview, an introduction. Then Mr. Hassler will address the factual reasons or the reasons why the facts in this case do not support the relief that the Attorney General is asking for. Mr. Coburn then will discuss some of the legal issues as well as describing for the court the new procedures that Enbridge has put into place to minimize the risk of anchor strikes.
Fair enough. Mr. Coburn, sir, you may proceed.
Thank you, Your Honor, and good afternoon. We've read Your Honor's June 25th order, of course, and we hope today to address any questions that remain following our written submission this past Friday. I know it was a large volume of material, and I apologize for that, but we wanted to be sure to address all of your questions, and we've tried to do that. The burden of supporting the Attorney General's preliminary injunction motion is, of course, on the Attorney General. She has not come close to meeting it. The Attorney General's request for a preliminary injunction is, from a legal point of view, fatally deficient because neither the Attorney General nor any other organ of the state of Michigan, or any other state that matter, can serve as the regulator of an interstate pipeline. The state is preempted from doing so expressly by the Pipeline Safety Act. The case law that we've discussed in our briefs makes clear that it isn't just a matter of the state not being able to adopt a specific safety regulation. The state simply cannot regulate, and the regulation that Mr. Reichel described is the most extreme form of regulation. It's regulation that would force the closure of the pipeline, certainly subsumed within the Federal Pipeline Safety Act preemption. I'll describe later the notion that their notion that the easement or the second agreement gives the state authority to be another regulator with PHMSA simply doesn't hold up to analysis. We'll also show that the Attorney General's case is basically based on fear, not facts. And her fear is not warranted by the facts here. Our safety regulator, PHMSA, has already determined that the West Line can be restarted. That point is reiterated in the June 29th letter that PHMSA wrote to Enbridge and that we submitted within minutes of receiving it yesterday. We submitted to the court and we submitted it to the Attorney General's office as soon as we received it yesterday. The letter underscores that the West Line at this point, not an issue at all. PHMSA is continuing to investigate the status of the East Line, on which a pipeline support, but not the pipeline itself, was struck. That too is made clear in the June 29th letter. PHMSA has authority to investigate, to order remedial action if they think it's warranted. Enbridge will not operate the East Line until PHMSA has determined that it is comfortable with Enbridge doing so. PHMSA's obviously deliberate approach here is the normal and proper way to regulate pipeline safety. Enbridge is cooperating with the investigation and will comply with PHMSA's directives. The citizens of Michigan can rest assured that PHMSA is doing its job. Yesterday's letter demonstrates that. Duplicative state regulation will only enhance conflict and confusion. It won't enhance safety. Before I offer detail on these legal issues, my colleague, Bill Hassler, will demonstrate that the facts also fail to support the proposition on which the Attorney General focuses her request for injunctive relief, namely that there is some imminent threat to the pipelines that would warrant extraordinary injunctive relief in the form of an order requiring that they be closed. In other words, we will show, Mr. Hassler will show that the irreparable injury test that the Attorney General has the burden to meet has not been met. And on that basis, on the same facts, the likelihood of success on the merits test has not been met. After Mr. Hassler makes his presentation, I will offer further views on the steps that Enbridge has taken to mitigate the risk of anchor strikes. And I'll get back to the legal points that I alluded to at the outset of my presentation to demonstrate that that state lacks the authority to do what Mr. Reichel proposes with respect to injunctive relief requiring the closure of the pipelines for any period of time. So with that, I'll turn the mic over to Mr. Hassler.
Thank you, Mr. Coburn. Mr. Hassler, go right ahead, sir.
Thank you, Your Honor. Good afternoon. I have two goals for my part of the discussion. Excuse me 1 second, Your Honor. Mr. Coburn, could you reduce your volume? We were getting some feedback here, Your Honor. I have two goals. One is to provide the court with a summary of the evidence that the West Line is fit for purpose in engineering terms. That is, that it's safe in layman's terms to operate. Second, Your Honor, I want to address some of the concerns that the court expressed in its order of June 25, where the court wanted additional evidence or additional explanation. We've tried to provide that in our papers, but frankly, Your Honor, I know how complicated this is, and I will try to elaborate to a certain extent. And to the extent the court has questions, frankly, in my presentation, I'm happy if you ask now. I know the court had indicated that you plan to come back to that, but I believe there are a number of technical issues where a dialogue might be more useful than simply an oral argument. In any event, let me start with the scientific and engineering proof that's before the court as to the safety of the line. Enbridge has provided materials, including its integrity assessment and its engineer for the West Line and its engineering assessment for the East Line. PHMSA has provided a official government document indicating PHMSA's view after review of the data that the West Line is safe to operate. At this point, the state has not offered any evidence in terms of safety. PHMSA's view is important, Your Honor, but the company's is also, and mainly because, Your Honor, it's the company that has been operating Line 5 in the Straits for over 60 years, during which time there has not been a single release of oil into the Straits. Enbridge takes great care and great pride in operating the line safely, has done that for more than 60 years, and continues to do that. What's ironic about the timing of this motion, Your Honor, is that frankly, Line 5 in the Straits is certainly safer today than it was at the time the line opened in 1953. Today, we have the kinds of technology that Mr. Reichel mentioned. For example, the inline inspection tools that have revolutionized the way pipelines monitor their own safety. But beyond that, Your Honor, Line 5 today is safer than it was the day the Attorney General filed suit. That Mr. Mueller's affidavit makes clear the measures that Enbridge has implemented to avoid future anchor strikes, and those are new since this lawsuit. The Attorney General did not seek an injunction when she originally filed suit a year ago. Now, after the implementation of additional measures, she is seeking an injunction. Now, if something had happened that warranted that, Your Honor, it would at least logically make sense. But as I will indicate, nothing has happened that the two incidents that we're looking at on the East Line and the West Line, in fact, do not alter the analysis of how safe the line is. Excuse me 1 second, Your Honor. Now, let me turn to the issues. And Your Honor, I've been a lawyer for a long time. I'm going to ask you a question I've never asked a judge. May I have permission to share my screen?
Sure.
Thank you, Your Honor.
You can show us all how well it works.
Well, I practiced last night. I hope it does work. Your Honor, can you see the screen?
I can.
Very good, Your Honor.
Give me
This-
one moment, Mr. Hassler, so that we can get it sorted for the public access. Okay, thank you.
May I proceed, Your Honor?
Yes.
Your Honor, here we have a demonstrative exhibit that's been provided to both the court and to the Attorney General's office that gives an overview of the straits and where the features of concern in today's argument are located. I'll start with the left-hand view. What we have here is a essentially image of the straits. This may be a satellite view, I'm not sure. But the distance across where my cursor is going is approximately 4 miles. The distance between the two lines, the east and west line, is approximately 1,250 feet. These are round numbers, Your Honor, but they give a sense of perspective. The incidents that we'll be looking at today, Your Honor, are in the yellow circle here on the left-hand side, and they've been zoomed in on the right-hand side. So what we have is, on the west line, the feature of interest is where this yellow pin is. On the right side, Your Honor, we have the screw anchor assembly that was damaged and is bent. It's known as EP17-1. It's a complicated name. The engineers at Enbridge and with the EPA, the engineers helping the EPA, have come up with the nomenclature. I don't understand it, but it works for them. And that's the unique name that this anchor has. There's a third feature on the map, Your Honor, and that is, it says the east line feature of interest, which was not mentioned in our briefs, but I will explain when we get to it in terms of causation, how it is that this feature, which was identified this past May, and which the state was informed of, PHMSA was informed of, and EPA was informed of, how it helps solve the question of causation here. I would also note that between EP17-1 and the east line feature of interest, it's roughly 150 feet, Your Honor. I'm going to switch exhibits if I can. We'll see how I do. Forgive me, Your Honor, I'll be 1 second. I see. Your Honor, can you see the before and after pictures?
I can.
I wanted to make sure everyone had clear in their minds exactly the features that we're talking about. On the left-hand side is a picture from 2018 that was taken shortly before or shortly after this particular anchor was installed. On the right is a picture taken this June after the damage that is at issue occurred. Your Honor, I can provide a description of what the screw anchors do. I don't want to spend a lot of time on it, but I think it's fair to say that the anchors are installed to stabilize the line so that where the line is not resting on the bottom, which it is most of the way across the straits, that either it will not sag vertically, that the screw anchor can support it, or if there are currents going horizontally across the line, that the line is not disturbed by the currents, that it does not create a vibration in the line. The anchors, the easement itself contemplates that there will be spans in the line where it is not supported on the bottom, and provides that the spans shall not exceed 75 feet. There are natural currents in the straits that change the bottom from time to time. The bottom is not perfectly flat, and that's why the line can't rest on the bottom all the way across. At times, currents will push sand from under the line, and what's known as a span will occur. The easement provides that a span should not exceed 75 feet. Where a current over the winter, for example, Your Honor, would take a span that was, let's say, 40 feet one year when it's measured, and they're measured regularly now. If that span grew over the winter from current action to, let's say, 80 feet, Enbridge would, the next year, construction season, come along and install an anchor of this type to reduce the span to less than 75 feet. The EPA is also involved in this process. There's an EPA consent decree where the EPA has said, why don't you keep the spans to less than 65 feet so that they don't have a risk of growing to 75 feet. And those are the rules that we're following today, Your Honor. The current, well, I need to address one other issue that was in Mr. Miller's affidavit. The document you're looking at is Exhibit 1 to Mr. Maxwell's affidavit. Mr. Maxwell is the pipeline integrity engineer, who's the senior integrity engineer at Enbridge, who's looking into this instance, and he's done a great deal of work on it. Mr. Miller noted that the before picture is dated 2018 and not 2019, as is stated in the affidavit. I want to make clear, Your Honor, that in fact, we put in the wrong picture when we were finalizing the affidavit. That is not Mr. Maxwell's fault, Your Honor. That was the lawyer's fault. That was my fault. And I wouldn't want Your Honor to affect Your Honor's assessment of Mr. Maxwell's affidavit that the lawyers made a mistake. We were moving very, very quickly after receiving your order. And frankly, the papers weren't as polished as I would have liked. But you have my apology, Your Honor. But again, it wasn't Mr. Maxwell. I can say, Your Honor, that it is known that as of June 2019, the screw anchor was still upright. So we've narrowed down the period when the damage could have occurred to sometime between June 2019 and today, or June 18 when it was discovered. That we know the anchor was upright in June of 2019 because last June, a year ago, Enbridge was in the process of routinely installing additional anchors as needed under the EPA consent decree. At that time, the anchor known as EP 17-1 was used as a reference point to measure in order to install other anchors. And so divers saw this anchor. There may be pictures of it. I don't know, Your Honor, but we know it was upright, and that's where the analysis starts. Your Honor, I'm now going to go to the west line feature. I'm going to see. Hopefully, Your Honor, I will get better at this as we go forward. Your Honor, can you see what says west line feature of interest?
I can.
Thank you, Your Honor. Now, I will show with my cursor. This is the feature of interest on the west line. You can see a whitish spot that's referred to as a calcareous deposit in some of the affidavits, which is basically an area where there's an absence of the aquatic life you see on other parts of the line. I will say there is a black marking where my cursor now is, Your Honor. And it's my understanding that that's probably a shadow, that itself is not a feature, that the feature of interest is the white area. Beyond that, Your Honor, there's a purple curved object towards the bottom. And when I was speaking to Mr. Maxwell, I said, what is that? Is it part of the line? He says, no, that's part of the ROV, Your Honor, the remotely operated vehicle. In other words, the ROV has outside its camera this purple line that's essentially a measuring stick and allows people to see the perspective, how large something is using the purple. That's all it is. It has nothing to do with the line itself. Now, Your Honor, if we could, I'd like to turn to explaining the safety case that Enbridge made in its initial submission. That is the integrity assessment for the West Line. And Your Honor, I'm going to put on the screen Exhibit 3C of Mr. Maxwell's affidavit. Does Your Honor see a document dated June 24, 2020?
I do.
And Your Honor, this document is the essentially third version of the original assessment that started on June 20. And it concludes that the West Line is safe to operate. And in doing that, and we're going to get to, I think, some news here in a minute, the line looks at, for example, the remote operated vehicle and diver inspection. Your Honor, we could provide the videos, but frankly, they aren't worth looking at for someone who's not a specialist, but they have been provided to the state. I'm gonna, and can Your Honor see me scrolling down?
Yes.
Next, Your Honor, the document refers to close interval survey, CIS. That is a method for measuring the cathodic protection system that protects the line. Cathodic protection, as I understand it, is an electrical current that's passed through the line that prevents corrosion from forming on the metal parts of the line. It's important in protecting the line, and the cathodic protection system on line 5 is intact, and that's part of what this report says. Also, Your Honor, Mr. Miller, in his affidavit he submitted for the state, said he needed the data for this closed interval survey in order for him to assess the line. And we'll get to it in a minute, Your Honor, but Mr. Miller, excuse me, the state has that data, Your Honor. And I'll discuss that and show you that in a minute. In addition, as Mr. Reichel discussed, Enbridge looked at metal loss and geometry ILIs. Those are special types of ILIs. The metal loss would look at either gouges or corrosion. Geometry ILI is essentially dents. But what the purpose of looking at historical ILIs, I know in your TRO you questioned this, is there are a couple of reasons. First, it could be that if this happened, let's say 2 or 3 years ago, it could be an ILI detected it then, that it wasn't noticed in reviewing the ILI data. But now if you go back and look at the particular location of the line, you can see it was there 2 or 3 years ago. So it can help date the incident. In addition, if there's an absence of any indication where this is, it suggests one of two things. Either it was very minor, so that it had no impact in terms of a dent or corrosion or metal loss, or that it happened after the ILI event. So it's not dispositive by itself, but it's something worth looking at. Now, I'll note that Mr. Reichel again said that Mr. Miller, as he stated in Mr. Miller's affidavit, said he lacked the data for this. Your Honor, I don't think that's right either, and we'll go over that in a minute. That the state, in fact, has the close interval survey information. They also have the ILI information, and we'll get to that in just a second. The conclusion in this integrity assessment is that the feature does not constitute an integrity concern to the pipeline. Now, and that is what Enbridge, in fact, believes today. Enbridge, however, is not alone in believing that. If I could, Your Honor, I'm going to pull up the PHMSA letter. Give me 1 second. Your Honor, do you see the June 29 PHMSA letter on the screen?
I do.
This letter is important in a variety of ways. In terms of the West Line and its safety, however, there are two references that I want to make sure, I'm sure the court saw them, but I should state them for the record. That first, I'm going down on the first page towards the end of the last paragraph where my cursor now is, and let me see if I can, I was going to try to do some of the things that you can do with share screen. Well, I won't try to be fancy, Your Honor. That it.
Do you want to use my highlighted version?
If Your Honor would like to read it, that would be fine, but thank you, Your Honor. What I'm looking at is here at the bottom, it says PHMSA is a review of video footage from the ROV of the West Leg, as well as other technical information provided by Enbridge, provided no indication of any safety-related concerns regarding the West Leg. It goes on to say, and Your Honor probably saw this in the papers, I won't belabor it, that PHMSA did ask Enbridge to restart during daylight. The reason for that, of course, is that if something went wrong and oil were to be released, it would be observed quickly and the line could be stopped. That it monitored the restart and that it notified public officials, and we understand that Enbridge complied. So that's, all of that was done. That's, I believe, in either the Kobe or Maxwell affidavits. And then I'm going to go down to page 4, Your Honor, where again, it says with regard to the West Leg, PHMSA has not identified any safety concerns and based on available information, has no technical or safety-related objection to continued operation of that leg. So what we have, Your Honor, is both Enbridge's engineering opinion and PHMSA's regulatory opinion that the line is safe. We have no opinion from the state, no expert opinion, that it's not safe. Under those circumstances, Your Honor, there is no reason that the West Line should not restart now. Now, that doesn't mean the state's not entitled to the documents and information that it's seeking. We are prepared to provide that. But there's no reason that the line should be shut while documents are collected. Your Honor, I'm now going to pull up the Miller affidavit. Mr. Miller is the engineer with the Public Service Commission who had indicated that he needed additional data. Mr. Reichel noted that he lacked ILI data, that is inline inspection data. Forgive me 1 second while I try to do that. Your Honor, you should see on the screen paragraph 18 of Mr. Miller's affidavit. I can show the first page if it would be helpful, but I assume everyone is willing to proceed in the interest of time from here.
That's fine. I can see it. Go right ahead, Mr. Haskell.
Your Honor, paragraph 18, I've highlighted the key language. It's Enbridge stated that they correlated the previous inline inspections and cathodic protection data to current areas where there are coating damage. Enbridge has not provided underlying data to support that correlation of these different data sets. Your Honor, one of the difficulties in moving as quickly as the parties have when one party seeks emergency relief is that people make mistakes. I indicated previously that the photograph in the affidavit earlier was my mistake. There are some other mistakes in our briefs where they aren't as polished as they should be. There's some gaps. But here, the state made a mistake, Your Honor, that the state does have the inline inspection and in cathodic protection data that Mr. Miller says they do not. And I will show you why I believe that in 1 second, Your Honor. Let me pull up the next document. Your Honor, can you see a letter dated January 9, 2020?
Yes.
This is a letter that Mr. Moeller of Enbridge, this is the same Mr. Moeller who submitted an affidavit, sent to Director Clark of the Michigan Department of, that time, well, it says Department of Environmental Quality. I believe probably its name had changed to Eagle at that point, and to Director Eichinger of the Michigan Department of Natural Resources in January of this year, approximately 6 months ago. This was done under the agreements that Enbridge signed with the state to share information in 2018, which have been discussed by Mr. Reichel. What's at issue here is a Line 5 close interval survey final report. As I go down, Your Honor, I can see that it talks about cathodic protection as an electrochemical method by which corrosion can be prevented. And it goes on and talks about the report. And it talks about the results of the report. And it says, please contact Mr. Moeller with any questions. Now, Your Honor, by electronic hearing, this is all as deep as I intend to get in this, but I'll represent to you, Your Honor, that Enbridge produced to the state in January of 2020, that is 6 months ago, the close interval survey and cathodic protection data that Mr. Miller says he needs. I will say right now, Your Honor, I assume Mr. Miller did not know that. I assume that the problem here is not lack of data. It's a right-hand, left-hand problem where Enbridge has given data to the state, but certain parts of the state aren't aware of it. I assume, frankly, that Mr. Bach and Mr. Reichel are probably unaware that other agencies have this data. I've worked with Mr. Bach in other cases. Our firm has worked with Mr. Reichel. They're both fine attorneys. We're not suggesting anything improper. What we're suggesting is that mistakes can be made. And here, Mr. Miller made a mistake, that the state has this data. Now, Your Honor, the other data that Mr. Reichel focused on, and that is in Mr. Miller's affidavit, is that he lacked the underlying data for inline inspection reports, ILIs. And Your Honor, that one, there's an interesting issue here, Your Honor. First of all, let me show you. You see my screen, Your Honor, it should say new MagnaScan geometry.
Yes.
Inspection report for 20-inch crude oil pipeline. So this is a report that's been produced to the state. It turns out this is one of the most recent reports for Line 5. You can see here for the west leg, which is where this feature is, it's dated January of 2020. And if at the bottom of it, you can see the Bates number where it was produced. Now, it was produced, Your Honor, pursuant to a request by Director Eichinger of the Department of Natural Resources, where he asked for inspections and Enbridge voluntarily provided them. And it goes beyond this one report, Your Honor. I can tell you it was our goal in responding to this report to produce every ILI inspection that has been run in the Straits since ILIs were first invented. That goes back to around the year 2000. Again, I haven't checked to see if we missed one, but I can tell you, Your Honor, that between the years 1998 and the current year, 2020, we have tried to produce every ILI report that has been run in the Straits. And I believe we have done that, but if we've missed one, I'll stand corrected later. But we have produced dozens of reports, all of which DNR's counsel have. We provided it to the counsel. Director Eichinger asked us to provide it to. That in discussing ILI reports, I should make clear what we're talking about, because there can be what's a complicated subject. And Your Honor, this is the way I understand it, that for every ILI inspection that's run, that the vendor, Enbridge does not do its own reports. I should say, you see here Baker Hughes. That's the name of an independent company that has tools that run for different pipeline companies all over the country. And the tool will go from one company to another company, from one line to another company. They have to be scheduled in advance. But basically the vendor controls the tool. When the vendor finishes the inspection, you then go back and analyze millions and millions of bits of data. The way an ILI works, Your Honor, is that as the tool, which is a large metal object, large cylindrical object, in my mind, it looks sort of like a torpedo going through the line. That's a simplistic view, but it's my view. And as it goes through the line, there are sensors that every inch or 2 inches, I don't know the specifications, wherever, very short distances, 360 degrees around the pipe, a measurement is taken of different kinds of sonic or other indications. And if you go over 4 miles, if you go over 100 miles, which is what some of these do, you collect millions of pieces of data. And so, this makes the tool enormously powerful and useful because you get a very detailed look at what is in the line, whether there are glitches, whether there is corrosion, whether there are cracks. But in order to process that data, after say Baker Hughes runs the tool, it then goes back and generates a report. And with every ILI inspection that we've produced to the state, there is a narrative report like the one we're looking at here. I'm going to make this a little smaller, where it has an executive summary, as Your Honor can probably see. And it's something that, Your Honor, you or I could read. It's fairly technical, but it's a narrative report. In addition, however, Your Honor, for every ILI that we've produced, to the extent we have the information, the vendor will generate what's known as a data listing, which is a large Excel spreadsheet that has the data that support the report. And for every inspection that we have the records for, we have produced to the state, pursuant to Director Eichinger's requests, the data listing for that ILI, that is the Excel spreadsheets. So essentially for every inspection, you have 4 documents. You'll have a narrative for the east line, a narrative for the west line, a data listing for the east line, a data listing for the west line. We've produced all of those to the extent, or we've intended to, I'll say that, because I'm sure we may go back later and find we missed one. But I will say 99% of what the state asks for, it should have. I hope they have 100%. And to the extent Mr. Miller says that he doesn't have access to that, Your Honor, the problem is not that Enbridge failed to produce it to the state. I can tell you the document we're looking at was produced on May 8th of this year. That is, it predates this incident. Other ILI reports were produced earlier than that, in April or maybe even in March. Some ILI reports were produced to the prior Attorney General in 2013 or 14. The state has these documents, Your Honor. Now, I said I thought that the problem here, Your Honor, is a left-hand, right-hand problem. I'm not accusing anybody of bad faith, but there are some lessons to be learned. In terms of this being an emergency motion, Your Honor, I find it troubling that we are here before you where the state says we don't have something and we say they do. That, as I indicated, I graduated law school, Your Honor, in 1980. It's been 40 years. And when I was a young lawyer, I loved document disputes. But as time went by, it became clear to me that 99% of document disputes can be resolved by competent counsel on each side, dealing with each other in good faith. And I frankly believe, Your Honor, that's what would have happened here if this were not an emergency motion. As I said, I worked with Mr. Bach, both for him and against him, and we've had a good relationship in both situations. I know Mr. Ellsworth is an experienced counsel and has dealt with the state frequently. Mr. Coburn has dealt with Mr. Reichel. If you put the five of us in a room, Your Honor, without an emergency motion, this kind of thing wouldn't have happened. I will tell you, Your Honor, when the state says they want all documents, I didn't know until yesterday when I got Mr. Miller's affidavit that this is what the problem was. And I would suggest, Your Honor, to the extent Your Honor wants documents to be provided, that one of the steps that should be involved is that counsel confer in good faith, as they frequently do, and we're certainly prepared to do that. Now, I will say now, Your Honor, Enbridge has agreed to provide the state all documents that we give to PHMSA. And when we go over the PHMSA letter a little later, that's going to be a substantial volume of documents that PHMSA has asked for, a substantial volume of material on the East Line, and we will provide that without hesitation as promptly as we can. I will also say, Your Honor, we are still in the process of providing videos, which it's not as easy as it sounds. With most documents, if you have a 5-page document, you walk down the hall, you photocopy it, you PDF it, you send it to the other side. Remember, Your Honor, these videos are being generated 240 feet beneath the Straits of Mackinac. That they are large files. That first it goes to the company that runs the ROV. Eventually it gets to Enbridge, and eventually it can be produced. But it's not a simple process, and the files, if you have a many hours long video, are very long. In addition, Your Honor, one of the difficulties here is that Enbridge is investigating both of these incidents very aggressively. We are still looking for evidence about causes. So that, for example, this past weekend, there were other ROVs being run. I have no idea if those have been produced yet, Your Honor, but I will say in good faith, it's our intention to produce them as soon as they're reasonably available. I assume that will be satisfactory to Mr. Bach and Mr. Reichel going forward, but I have to say that a request for documents within 24 hours of their being created is not going to work, particularly, Your Honor, if you go back to the first weekend here. You've got people, the engineering team, running around like crazy, trying to find out how big a problem there is and what the problem is and what the technical data is. The idea that they should then spend a lot of their time trying to produce documents to the lawyers, on a 24-hour turnaround doesn't make a lot of sense, Your Honor. When you're fighting to deal with a potential emergency, you need time to deal with the emergency and then produce documents. And so, in Your Honor, I mean, my takeaway is, frankly, the parties together can do better here. We should not be taking Your Honor's time. The court shouldn't even have to rule on this. I think we could work it out, much less the idea that Your Honor would issue an injunction based on these kinds of document disputes. To my mind, it's not consistent with my experience as a lawyer over the last decades. Your Honor, I'd like to turn to the causation issue, if I may. Your Honor's order of June 25 on page 3 said that one of the things the court thought it needed to know more about was what might have caused the feature of interest on the west line. I believe that's a quote. I'm going to respond to that now, Your Honor, with the information that we currently have, but I do need to give one word of caution. As I said, the investigation is still going on. Enbridge is working very hard to find out everything it can about what happened here. It's possible that, and I will tell you what is currently known, but it's possible more information will be found in the future that may cause the company to revise its position. And so I just want to say now, the fact that the position may change doesn't mean that we aren't giving you the best information we have right now. Beyond that, Your Honor, although I'm going to summarize what there is, this is covered in Mr. Maxwell's affidavit. And so to the extent Your Honor wants written statements by someone who is an engineer, unlike myself, that's available. Now, we know a fair amount today, I can say, Your Honor. And we know enough for me to say, for example, I'm going to go back to the demonstrative for a second. As indicated here, Your Honor, we have the west line feature of interest and the EP 17-1, which is where the screw anchor assembly is that's bent. Does Your Honor have those on your screen?
Yes.
Thank you, Your Honor. I think it's the company's current understanding is that the west line feature and the damage at EP 17-1 were not caused by a single source. We believe there was more than one source based on what we now are aware of. As I've said, that could change going forward, but I will tell you what we now know. Now, why do we believe that, Your Honor? The main reason is that the damage on the west line feature was probably done by a vessel dragging an object going in the east-west direction. That is, across the straits. Is my cursor, whoops, can you still see see it, Your Honor?
Yes.
Okay, I cannot. I'll have to, let me try again. I'm not sure what I did, Your Honor, but I will keep going. That the feature on the west line was caused by a vessel moving east to west through the straits. The feature at EP 17 was probably caused by a different vessel moving north-south that is parallel to the pipeline. So I think the language in either the affidavit or the brief is that the west line feature was caused by a vessel moving perpendicular to the pipeline. The east line feature was caused by a vessel moving parallel to the pipeline. And those have implications for the size of the vessel and what was happening. Your Honor, I'm going to try to, I can't see the screen, so I'm going to take it off and try to go back to where I was if I can. Oh, here we go. All right, can Your Honor see the demonstrative?
Yes.
So Your Honor, I was able to do a nice line drawing exercise last night when I practiced, but since I can't do that now, I'll simply say that the primary evidence regarding the west line and the direction of the vessel is that there is a drag mark in the bottom of the straits that the ROV videos picked up. And I'll show you that drag mark in a minute, but it leads up to the feature on the west line. In addition, the drag mark proceeds, can you see my cursor, Your Honor?
Yes.
That the drag mark proceeds from this feature where it's first noticed and goes across the line to a similar feature on the east line. Now, I will say the drag mark goes beyond that. It then goes east beyond the east line, way off into the strait, or this is toward the bridge to the east. And on the west, it also goes off a considerable distance to the west. Enbridge has had ROVs deployed to try to follow the drag mark and get as much information as we can from it. Before I go further, though, let me call up the photo that will allow you to see the drag mark yourself, Your Honor, so that it makes more sense. The photo I'm going to show you, Your Honor, is from Mr. Maxwell's affidavit. It's from Exhibit 3C. It's Figure 2 in Exhibit 3C. And this is an enlargement of it so that we can see it more easily. I've added the red circles on the picture. Those were not in it originally. Here is the west line feature. And where my cursor is here, you can, I think Your Honor probably can see the drag mark. I'm told there are better ways to see it, but this is what we have available. So this drag mark you see here goes off to the east a long way, goes off to the west a long way. And that is the evidence that the vessel moving through the line or that caused this damage is moving east-west. Beyond that, Your Honor, the drag mark itself provides critical evidence. The drag is very light and very thin. It's clear that this is not an anchor being dragged. And we can have engineers discuss that going forward, but our conclusions based on what is now known is it's a thin object, something like a cable. We're not saying it is a cable because we don't know that yet, but something like that. The other reason, and it's light, it's not heavy because you can see it does not dig deeply into the bottom. In addition, where the object probably went over the pipeline, it barely had any impact. That you can see there's the one area where the muscles are off, but other than that, it had no further impact. Your Honor, I skipped over the dive reports, but the divers came and looked at this. They tried to figure out if the coating had been removed. And I should have mentioned, if you look at Maxwell Exhibit 4, there were actually tests done on the coating that measured its thickness. There are tools that can do that, even 240 feet under the water. And the finding was that the coating where this red circle is thinner than in other places. So there may have been some effect on the coating, but it's still intact and there is no bare metal. By way of full disclosure, Your Honor, I will tell you that one of the divers at one point thought he saw bare metal. There's difficulty in interpretation here because you're 240 feet under the water. The light is poor. You're using artificial lights. They create reflections. And it's hard to know if what you see is a reflection off of one thing or off of bare metal. That the diver reported what he saw. They went back to analysts. They took the video, they reviewed it, and they concluded it's not bare metal. And we believe it's not. But to the extent Mr. Miller or others from the state want to look at it, we want to be clear that there was some question at one point. We think it's not there. But in any event, this is not a major impact. This was a light object going east to west. Excuse me while I review my notes, Your Honor. Oh, finally, Your Honor, one of the issues is preventive measures that Mr. Miller mentions that he's read Mr. Moeller's affidavit. Mr. Moeller presented a summary of the measures that the state, that Enbridge has taken to prevent anchor strikes going forward, in part as a result of what happened in 2018. And Mr. Miller says, well, they didn't prevent this, so how do you know they work? And I think it's fair to say this was not an anchor strike, Your Honor. As I said, this is a very light drag, and it's not clear what it was, but we're very clear it's not an anchor. So that the measures where there are boats in the straits looking to see if an anchor is deployed, it's not a test of that by any means, Your Honor. This is an object, Mr. Maxwell has opined, that could not damage the pipeline. The pipeline is 0.812 inches thick. That's 13/16 of an inch. That's very thick as pipelines go. That a cable or other similar object, if it came into contact with the pipeline, would not do significant damage, would not threaten the integrity, and did not in this case. Your Honor, I was going to move to the east leg unless you have questions about the west at this point.
Go right ahead.
Thank you, Your Honor. So we have the demonstrative again. Here is EP 17-1. Now, what's interesting about this feature in terms of causation is that evidence of the damage to the anchor assembly itself, as well as other evidence where there are scrapes on the pipeline in nearby locations, suggest that the vehicle or the vessel that caused this damage was moving parallel to the pipeline, over the top of the pipeline. That evidence includes the direction the anchor assembly itself is bent in, which is down parallel to the pipeline. It also includes scrapes that Your Honor has not heard about or seen pictures of, but which are available, that Enbridge engineers have reviewed. Those scrapes show a scrape along the pipeline within 150 feet of EP 17, somewhere in here where my cursor is. Those scrapes, Your Honor, were detected in May. They were reported to the state in May. They were reported to EPA in May. They were reported to PHMSA in May. Now, at that point, no one had seen EP 17-1, but people did see the scrapes. And Enbridge looked at them, reported them, and repaired them. There was no motion for a TRO or for preliminary injunction. We believe that the same cause for those scrapes is what caused the screw anchor assembly to be bent. Now, Your Honor, I believe it's Exhibit D as in David to the state's initial motion, which was submitted after the fact because the state was being cautious about not producing confidential information, and we appreciate that. We're not being critical. But that exhibit is Enbridge's engineering assessment for the East Line. That exhibit, which I'll pull up if I can, 1 second. Does Your Honor see Exhibit D?
Yes.
This is the June 21, 2020 engineering assessment for the east leg. And I'm not going to go through all of this. I'm only going to cover the parts that deal with causation. But the important part here is the statement I've highlighted that says the longitudinal loading experienced by the anchor, that is the anchor assembly, and resulting stress is between 60 to 77 times lower than the engineering design of the pipeline critical strength. That is, whatever blow struck the screw anchor was a tiny fraction of what would be needed to do damage to the line itself. And so we see that here. This is the force that's been calculated by the engineers in terms of pounds of force for the damage to the anchor. And the number here, which is many times higher, is the pipeline's own resistance to drag forces. The significance of this, Your Honor, in terms of causation, is that it allows Enbridge to conclude that, well, it's one of two lines. Enbridge has concluded that since this vessel that was dragging some object, and we don't know what it was, we don't know if it was an anchor or something else, I'm not going to go beyond what we know. But the vessel was moving north to south based on the drag marks and the bend of the anchor. Large cargo vessels in the Straits generally do not move north to south. They go east to west through the Straits. They don't go from one side of the Straits to the other. And so we believe it's very unlikely that this was a large vessel with a large anchor. We're going to check that we have a system that monitors every ship that goes through the Straits. And we're looking at that now, but we think it's very, very unlikely that the vessel moving north to south was a large vessel with the kind of power and weight of its anchor that would affect the line. What this is consistent with, Your Honor, is a moderate-sized vessel, as Mr. Maxwell's affidavit says, moving parallel to the line, and there could be vessels like that. And an area of great interest, I can assure you, at Enbridge today is to determine what kind of vessel it was, what vessel it was, what could be done to prevent this. Now, because Enbridge doesn't want any damage to its pipeline. But the important thing here is that if this is a moderate-sized vessel, it is not capable of damaging the line because the forces it can exert and the weight of any object it would drag is much, much, much less than the pipeline's ability to resist that force. But I want to stress, we're still investigating. We want to find out more. And if we find out more, we're going to implement still other measures to prevent further damage of this type in the future. Now, Your Honor, at this point, and I know we've been going for a while, Your Honor. If anyone needs a break, I'm happy to keep going, but I've got a little bit more, Your Honor.
Well, actually, Ms. Dexter has requested a break. So we will take a break before we go. So you'll come back, Mr. Hassler. You want to do a little bit more before Mr. Coburn comes back on, I take it?
Yeah, that's exactly right, Your Honor. I don't have too much more. I'll try to move it along.
All right. So we will take a break. Before we take the break, I do want to say, Mr. Hessler, that you've referred several times to the engineers essentially educating you about this and your attempts to convey what you understand they have educated you about. And I'm assuming you, in exchange, agreed to educate them about some legal principles as well, like perhaps maybe the economic loss doctrine or something obscure like that. Perhaps you agreed to exchange with them. With that, we'll take our break. Ms. Dexter, about, what would you like, 15 minutes?
Fine.
15 minutes and we'll come back on then.
Thank you, Your Honor.
You're welcome. Hassler, when you're ready, you can continue.
Thank you, Your Honor. And I hope to wrap up quite quickly. If I could turn back to any remaining document issues, I'm not sure what there is, but I will say Enbridge is committed to provide the state everything we provide PHMSA. I know Your Honor has read the letter from PHMSA dated yesterday, June 29. The middle portion of that letter has a very long list of requests of documents that Enbridge is going to need to provide PHMSA, including third-party reviews. Enbridge is going to provide those in 15 days or 30 days, as PHMSA requested, and the state will receive those. That, Your Honor, I think that is more than adequate in terms of the documents that the state should receive at this point. I will say, Your Honor, to the extent you disagree and you think we need to produce additional things, Your Honor can direct us to do that, and we will comply. But that's what's needed here. That's all that's needed here. An injunction is not needed to order us to produce documents. It's simply a direction of the court that, to the extent the state wants documents, they're entitled to seek them. But there is nothing in the second agreement that says if the state doesn't get documents, it's entitled to shut down the pipeline, which is essentially the relief they are asking for here. And the only other point I would make on their document request, Your Honor, is although it's somewhat disingenuous to hear that all they want is a root cause analysis. You know, that's not a request for an existing document. That's essentially either a contention, interrogatory, or request for expert discovery. That's something that ultimately Your Honor is going to have to decide. But if we produce the analysis they ask for, they'll never be satisfied. This isn't a matter of us reopening in a day or a week. It will go on forever, Your Honor. That's because whether the line is safe and whether it's adequate is what's being litigated here. The parties don't agree. Your Honor probably will have to ultimately decide it. But the idea that the state can stop the line until it's ultimately decided just turns the litigation on its head, Your Honor. That is not what should happen here. We have engineering reports from Enbridge that says the line's safe. We have PHMSA saying it thinks the line's safe. Your Honor, if the line is safe, it should be operating, or it should be allowed to operate. Let me turn to the issue of prudent operation of the line. Your Honor said that's important to you. It's important to Enbridge. If you look at, in order to sum up quickly, if you look at Mr. Maxwell's affidavit, the areas, I would start at paragraph 51 to the end, which is the conclusion. I'm not going to go over it, but those paragraphs lay out what it is that Enbridge has done to operate the line prudently and safely as a reasonable person would. The fact that they are doing that is probably best evidenced here by the fact that PHMSA has said the West Line can operate. That is by itself proof that it's prudent to operate the line. Let me conclude by saying this, Your Honor. The line today, as I said earlier, is safer than it was when it opened in 1953. The technology that Mr. Reichel talked about, the in-line inspections, have made preventive measures in the pipeline miles ahead of where they were before. There have been no spills in the last 60 years. There's no more reason to believe there will be in the remaining years before the tunnel project is implemented. I would say, Your Honor, in terms of specific items that will allow Your Honor to be assured of the safety of the line, the kinds of protections it has now include 24-hour a day, 7 days a week monitoring. The line is operated by controllers and operators in a master control room that constantly monitor the line, its temperature and its pressure. There are sensors at every point on the line that if there is a release, they will know quickly they can turn the line off. For the last 20 years, the company has had the ILI technology that Mr. Reichel mentioned. And in recent years, we have the items in Mr. Moeller's affidavit to prevent anchor strikes that Mr. Coburn will talk about. When the Attorney General, excuse me, Your Honor, when the Attorney General filed suit, the Attorney General did not seek the kind of injunction she is seeking now. There's nothing that has happened that requires an injunction now. Your Honor, I will conclude my argument at this point. I know Your Honor may have questions later, and I will be available.
Thank you, Mr. Hassler. Mr. Coburn, I believe we're going back to you. Is that correct?
That's correct, Your Honor. Thank you. And I will try to be as brief as possible, given the approaching late hour. But I am going to stay on the facts for another minute before turning to the legal issues underlying this case. The one factual issue I want to emphasize is that Enbridge has aggressively addressed the issue of vessel anchor strikes and other objects potentially striking the pipeline or the pipeline's infrastructure. In that regard, I'll direct you to the affidavit of Mike Moeller, which was submitted with our presentation this past Friday. Mr. Moeller is the director of Enbridge's Great Lakes operations. His affidavit describes all of the steps Enbridge has taken to mitigate against the risk of such strikes. These include obtaining Coast Guard approval and then implementing an automated communication system, it's known as Guardian Protect, that broadcasts to every larger vessel that transits the straits well before the vessel crosses the pipelines. The broadcast message advises the vessels about the presence of the pipelines and the existence of a no anchor zone that the Coast Guard has adopted surrounding them. That's a regulated no anchor zone. Vessels can only drop anchors in that area with advance permission from the Coast Guard and only with a very good reason. This is in addition to virtual or electronic buoys that every vessel can find on its electronic charts. Importantly, in addition to onshore and on the water observations that Enbridge makes from patrol boats that it operates to determine the status of the anchors of each vessel transiting the straits. These and other measures were described in a May 21 letter that was Exhibit 1 to Mr. Moeller's affidavit. It was a letter that Enbridge wrote to Eagle and to MDNR with a copy to the governor's office, explaining all of the measures that Enbridge has taken, explaining that these agencies have been kept abreast throughout the development of these measures. It also invited the agencies to express any concerns they might have, raise any questions they might have. We haven't heard from Eagle or MDNR about any concerns or any questions concerning the anchor strike issue, which is, of course, central to the Attorney General's case. Further, Enbridge has very recently adopted additional measures that are now in place, which include not only radio hailing vessels, if there's any question about the status of their anchor, but also stationing a vessel over the pipelines 24 hours a day, 7 days a week, to identify any risk that any transiting vessel, whether it be north-south or east-west, may pose to the pipelines. We've also submitted, Your Honor, on Friday, the affidavit of a former or retired Admiral, Roy Nash, who has studied these measures that Enbridge has imposed and advised us that the measures significantly reduce, his words, the risk of anchor strikes. Now, as Mr. Hassler has explained, there is no indication that the impacts to the lines or the pipeline or to the pipeline support in the case of the East Line have resulted in our being here today, that those impacts resulted from a large vessel dragging a large anchor while transiting the straits. As you heard, the impact to the East Line were more consistent with a smaller or moderate sized vessel, and the And in the case of the West Line, the area where the biota was scraped off resulted from not an anchor drag at all, but from a thin cable or wire or some similar object. Thus, there's no reason to believe that the measures Enbridge has put in hand are not working, because they're designed to address the more significant risk of a larger vessel with a larger anchor striking the pipelines. The impacts that resulted in us being here today were not those kinds of high impact events that we are taking these anchor strike mitigation measures to prevent. And again, the most recent measure that we've implemented of stationing a vessel directly over the pipelines will address any risk to the pipelines of any kind of strike. I want to switch gears and talk about the legal issues in the case. Because we've argued from the outset of this case, not just in connection with this injunction proceeding, but in connection with the complaint that launched the case, that the state is not entitled to relief on federal legal grounds. It can't, either on a temporary basis or a permanent basis, seek the closure of these pipelines. To put that point in context, we've studied the law very carefully. We have not found one case from any state in which a state agency or a state court has compelled the closure of an interstate pipeline for safety reasons perceived by that state. Not one case. So again, not once in our knowledge has a state successfully forced the closure of an interstate pipeline because it deemed the pipeline too unsafe to operate. And the state has cited no precedent. So I think that puts these issues in context. Notably, the pipeline here is not even just an interstate pipeline, it's an international pipeline that serves US energy objectives. And no state, again, has ever sought to close an international pipeline on the basis of safety concerns. Now, I'm not going to dwell at length on PHMSA's role as the safety regulator. We've dealt with that in quite a bit of detail in our papers. And the state has, in fact, acknowledged in its most recent papers, for the first time, PHMSA's role in regulating safety. They did not acknowledge that at all in their PI or TRO papers. I don't think they even mentioned PHMSA. And they've acknowledged it. They have acknowledged it in the past, though. Mr. Bach, at a hearing that was held in a proceeding before Eagle, involving the installation of the kind of screw anchor that is involved in the East Line incident, said at that hearing that if there is a weakening of the structure of Line 5 resulting from the installation of the screw anchors, as had been alleged in that case, quote, that is within the specific purview of the Pipeline Safety Act. We also have a longer quote from that proceeding in our brief, in which again it is acknowledged that the Pipeline Safety Act, that is the federal law, is paramount here. But while acknowledging PHMSA's role, the state now argues that the easement's due care terms provide the state with its own parallel safety responsibility, that is parallel to PHMSA's role. So just to put that in perspective, having previously contended in her initial complaint that the easement is invalid, which apparently is still their position, and then having previously denied that this case was even about safety, having contended in their papers on our motion to dismiss that it was really about location, the AG has now pivoted again. Today, she bases her case squarely on the terms of an easement that she simultaneously claims is invalid. And at the same time, she has now finally acknowledged that her case is really all about safety, as we have argued from the outset. But this latest effort to refashion her claims also fails. She's come up with an easement-based theory of state safety regulation that not one of her predecessors over 60 plus years that the pipeline and the easement have been in place has asserted. As we understand the latest twist in the Attorney General's argument, the state is saying that Enbridge has contractually agreed through its acceptance of the due care provision in the easement to provide the state with information relevant to allow the state to, quote, discharge its perpetual duty to protect the public trust in the Great Lakes bottomlands. That's a quote from the Attorney General's most recent papers. Now, although her papers don't say it in so many words, the clear implication, more than the implication of what you've heard today from Mr. Reichel, is that the Attorney General is asserting a right to seek the injunction that they're seeking here to prevent the pipelines from operating on safety grounds, while the state assesses that safety based on information Enbridge provides. The state's apparent goal is to prevent Enbridge from making, and again, I'm quoting from their papers, a unilateral assertion that it has satisfied the due care obligations. So the Attorney General has already retained an employee from the Michigan Public Service Commission who claims to be knowledgeable in pipeline safety, and at the same time, the state also claims to be actively working to secure outside resources to enhance its technical review. Importantly, the Attorney General does not deny that if its technical reviewers conclude within the 14 days they say they need that the lines are unsafe, the state will want the injunction to stay in place indefinitely. Presumably that would be their intention, is to have the injunction stay in place for as long as it takes them until at some point in the future, maybe they issue a green light decision after whatever demands or mitigation measures, and they have discussed the imposition of mitigation measures, are met. Well, we know the Attorney General's position is that these pipelines should be closed. She ran for office on that platform, so we know her position. So what they're doing is asking us to put the pipeline in the hands of a state instrumentality that never wants to see the pipelines open again. We submit that that is unreasonable, but it is more than unreasonable. The argument that they think they have the right to do that is fundamentally flawed. First of all, the due care provision in the easement imposes obligations on Enbridge. It doesn't vest regulatory authority in the state. The obligation it imposes on Enbridge is to exercise due care in the way in which the pipelines are maintained and operated. Enbridge meets that due care obligation by adhering or acceding to PHMSA's regulatory requirements. Those regulatory requirements are the appropriate measure of our due care. We're not making unilateral due care assessments, as the Attorney General claims. PHMSA is the statutorily appointed overseer of whether we are adhering to the due care standard. It is not the state, and the due care provision does not purport to give the state such responsibility. If Enbridge is not acting consistent with its due care obligations in terms of safety, then the state can complain about that to PHMSA. What it cannot do is start regulating safety on its own. The assertion that the state authority is precluded, as we've discussed, by the Pipeline Safety Act's preemption provision, which is express and clear. Further, to illustrate why there is a preemption provision, if the state were to assume a regulatory role, we would immediately be in a situation where confusion and conflict between different safety standards, the state's as yet undefined safety standards, which they will apply to determining if we are a reasonably prudent operator, versus the Pipeline Safety Act safety standards adopted by PHMSA. there'll be a great opportunity for conflict there, and no guarantee that those conflicts would be readily or easily resolved. Indeed, we already have a conflict. We already have a conflict because PHMSA has said that we can operate the West Line. They've looked at it. They've looked at the facts and they've said it's safe. Go ahead, operate it. And the state at the same time is saying, don't operate it. So we're not talking about a hypothetical risk of a conflict. We're talking about an actual conflict already. And that would just get worse if the state were allowed to make its reasonably prudent determination based on whatever additional facts or materials they want Enbridge to provide. PHMSA is undertaking a complete investigation. We saw that in the June 29 letter. We're going to be providing the materials to them that they have asked for. And they will let us operate the East Line only after they determine that it is safe. That should be enough for the state to be satisfied that we will operate the line with due care. Now, the state dismisses the Olympic pipeline decisions we discuss, including the preliminary injunction decision in that case, which was attached to our submission this past Friday. Those cases are right on point, and I commend them to you, Your Honor, because there we had a situation where a pipeline company, it was somewhat reversed in the sense that the pipeline company sought to enjoin a city, the city of Seattle's effort to regulate the operation of an interstate pipeline, claiming that the pipeline was unsafe based on something that had happened in a nearby town. The city relied on a franchise agreement, similar to the easement agreement at issue here, in claiming the right to impose these safety requirements on the pipeline as a condition to its operation. And by the way, just as the Line 5, just as the dual pipelines rest on state-owned property, there the pipeline at issue rested on city-owned property. So very similar facts. And the court very easily found, both in denying the preliminary injunction and then in its final decision on the merits, that the city's claim was preempted by the Pipeline Safety Act. In fact, the case is even more parallel in the sense that there the city argued that they could do this because they could determine location, which is an argument we were hearing from the Attorney General, but apparently they've abandoned that argument. And the judge in the Olympic pipeline case said, no, this case is not about location. This case is about safety, just as our case here is about safety. The Attorney General seeks to distinguish the case, the Olympic pipeline case, on the ground that PHMSA had found that the safety rules that the city was trying to impose were not necessary. But that's the exact same situation we have here. Because here we have PHMSA saying the West Line can operate and the state saying, no, it can't. So again, there's a direct conflict between the two, just as there was in the Olympic case. So again, I commend that decision to you. I also commend the decision of Williams Pipeline versus City of Mounds, also cited in our supplemental brief and in our brief from last week. There, a Minnesota federal court case, a local government sought to impose its own safety regulation through a license agreement, again, analogous to the easement agreement here. And the pipeline company took them to court and said, no, you can't impose your own safety regulations because of the Pipeline Safety Act. And the court said noted that the pipeline ran, as Line 5 does, through numerous jurisdictions. And if each were, quote, entitled to demand compliance with their own safety standards, the clear congressional goal of a national standard for hazardous liquid pipeline safety under the Pipeline Safety Act would be thwarted. a holding that I submit to you applies directly to what the state is trying to do here. They would thwart the national uniformity that the Pipeline Safety Act is trying to achieve in terms of the safety of interstate pipelines that cross numerous political boundaries. So again, the first point I'm making here is that the state's reading of the due care provisions is overly broad. Those provisions do not assign the kind of active safety role that the state is seeking to achieve here. They don't set the state up as a parallel safety body that can enforce its will through injunctions. This reading of the due care provision results in the direct conflict with the PSA that I've described. None of which is to say that we don't recognize that we have a responsibility to keep the state informed. We do, and we are. As Mr. Hassler described in detail, we've provided a huge amount of documents, more than the Attorney General recognizes, to the state, and we will continue to provide documents as per our obligation under the second agreement, and under and in order to demonstrate to the state that we are in fact meeting our due care obligation by complying with PHMSA's regulations. Now, the state notes that the due care provision in the easement predates the Pipeline Safety Act. So presumably they're saying that, well, because the Pipeline Safety Act wasn't enacted in 1953, by the way, it was enacted in 1979, they're suggesting it doesn't apply, or at least that the preemption provision somehow doesn't apply. But that, I submit to you, is an absurd interpretation of the Pipeline Safety Act. When Congress passed the law and included a preemption, it didn't say, oh, and by the way, if a state had been previously regulating pipelines, it can continue to do so. That would undermine the whole purpose of national uniformity that Congress was trying to achieve. Before there was a federal body, yes, states regulated pipelines, it's true. But that situation ended in 1979. And so the PSA, the important point is, of course, that the PSA is now in place. The preemption applies to any state effort to override it. There are no grandfather rights given to Michigan or any other state. If there were, the whole purpose of the act would be undermined. And then on the question of the pipeline being in the bottomlands of the straits, we pointed out in our supplemental brief that the Federal Submerged Lands Act of 1953, coincidentally 1953, clarified that states have an ownership interest. Yes, it clarified what had been understood for a very long time, that the states have an ownership interest in the bottomlands. As Mr. Reichel properly said, that interest had long been recognized to derive, I should say, from the Constitution. So the Submerged Lands Act didn't change the ownership, but it responded to some Supreme Court cases, and we discussed this in our supplemental brief, which cast some doubt on federal ownership. But even the Obrecht case, which the Attorney General, of course, relies on heavily in their brief, recognized that the Federal Submerged Lands Act made it clear that the state owns the bottomlands. But that's not the key point here. The key point is what the Federal Submerged Lands Act further provided, which is that notwithstanding state ownership, the federal government retains a regulatory responsibility, not just with respect to navigation, as Mr. Reichel suggested, but with respect to commerce. The words commerce and navigation, and other words as well, are used in the Submerged Lands Act. And the Pipeline Safety Act is, of course, based on the federal government's right to regulate interstate commerce. So what does all that mean? That means that the pipeline that exists on the bottomlands remains subject to federal regulation, notwithstanding that it rests on the bottomlands, and notwithstanding the state's public trust obligations. Those public trust obligations do not override the federal preemptive rights in the Pipeline Safety Act. And we have cited in our supplemental brief case law that supports that proposition. I'll direct you, Your Honor, when you have an opportunity to review the Weaver's Cove case that we cite, where the question was the location of a pipeline on the bottom of Narragansett Bay, which is like the Straits of Mackinac to the people of Rhode Island, understandably, just like Chesapeake Bay is in my state of Maryland. It's very precious waterway. We acknowledge that. The people of Rhode Island felt that they didn't want a pipeline in Narragansett Bay. The court held, though, that the pipeline could be placed there because the federal government's right to site a pipeline, this was a gas pipeline, so the regulatory structure is a little different, but the federal government's right to site it was assured by the Federal Submerged Lands Act, which gave the federal government paramount, and that's the word in the statute, paramount authority to regulate commerce in public trust bottomlands. Narragansett Bay, Straits of Mackinac, same principle. So I think we have some very powerful precedent in our supplemental brief, and I suggest that the state has no basis for their argument that somehow, because they have a public trust obligation, the Pipeline Safety Act preemption somehow doesn't apply. So the easement doesn't get the state where they'd like to go with the latest version of their claims. It doesn't give them rights that no other state has to become a second safety regulator. It doesn't allow them to demand that the pipeline be shut down while Enbridge does safety studies or root cause analyses that would satisfy them, but the PHMSA hasn't even asked for and may not. And it doesn't allow them to hold the pipeline operation hostage while they do their own safety assessment parallel to PHMSA's. Likewise, the second agreement doesn't help them in that regard at all. The second agreement, as Mr. Reichel well knows, he was involved in I believe, in the negotiation of it. The second agreement is an agreement that talks about our obligation to produce documents as are defined in that second agreement. It also, by the way, provides for semi-annual meetings between the state and Enbridge to discuss safety issues. But under this administration, this Attorney General administration, they've shown no interest in having such meetings. They've shown no interest in discussing anchor strike prevention measures and no interest in meetings that were designed to be informative. Instead, they've run to court and complained that we haven't produced documents that, in fact, we've already complained and we will produce more to their satisfaction. So one other point I'd like to make, Your Honor, before moving on to some other points. One other point on along the lines of the constitutional issue in this case. We noted in our brief filed this past Friday that not only is the state trenching on the Pipeline Safety Act, but also on the Dormant Commerce Clause, that the federal government regulates interstate instrumentalities like this pipeline. They can no longer force the closure of this pipeline than they can force the closure of a privately owned railroad that operates through the state of Michigan, or force the closure of an interstate highway. Doing so would violate the Commerce Clause, but we don't need to get into that issue because the Pipeline Safety Act is so clear. But one point that they make in their reply brief, I can't let go without saying something about. They say that there's no Commerce Clause violation here because the impact of a closure is only indirect. It wouldn't be all that great if they force the closure of the pipeline versus the constitutional right of the federal government and under the Constitution to regulate interstate commerce. But that's obviously not right. I mean, the impact is great. It's direct and immediate. Oil is not flowing to refineries that expect to receive the oil. It's not flowing into Canada. It's not flowing to Ohio. It's not flowing to Pennsylvania. The interstate commerce impacts are happening now as we speak. And yet they're trying to say that, well, they're just indirect. I mean, that I'm sorry, is not a position that is tenable. So there's no lawful basis. Bottom line, there's no lawful basis for the preliminary injunction they seek. There's no factual predicate for it, as Mr. Hassler has demonstrated. The pipelines are designed to withstand impacts orders of magnitude greater than the forces that were at work here that led us to be in the courtroom today. Despite the fear mongering that we hear from the Attorney General, these are not, again, not high impact or highly threatening events. These lines have operated for 67 years without one drop of oil spilling. That's worth taking into account in determining whether the state is entitled to a preliminary injunction based on the events that led to us being here today. Further, Enbridge throughout has acted responsibly. We've reported the events to the state timely. They haven't complained about that. And we've reported to our safety regulator very timely. We've documented what happened. We've investigated and we're continuing to do that. We're cooperating with PHMSA's investigation. We're working as best we can to determine the cause. We may never know the exact vessel at the exact time that these events happen, but we will look at the cause as best we can. As PHMSA's June 29 letter underscores, the West Line is already clearly safe to operate. The East Line, more investigation will be needed. But there is no likelihood, I submit to you, that the state could successfully show that we have not exercised due care, and no likelihood at all that they could succeed on the merits if we litigated this to full term. Turning to irreparable harm, very briefly, we've already shown that there's no imminent risk. And as to the new reasons offered by the Attorney General, their claimed frustration of their rights under the easement and the second agreement, we've already shown the state has no regulatory rights. So it therefore has suffered no frustration. That element of its irreparable harm claim fails. Further, to the extent that the state claims that it needs Enbridge's documents, that claim simply doesn't make sense. Again, as Mr. Hassler explained, the documents have been and will be provided. Turning to the balance of harms test, closing the dual pipelines closes all of Line 5. I think that's well understood. It cuts off an instrumentality of interstate and international commerce. It affects businesses throughout the region. And there's no good alternative. It's not as if there are other pipelines through which this oil can be transported. We have demonstrated that through the affidavit of a transportation economist, Neil Ernest, that there are simply no empty pipelines to reroute this oil in. If the oil does not get to where it is supposed to go, and as well as the natural gas liquids that are transported on this line, the implications for businesses in terms of job losses, in terms of businesses, including refineries that would be forced to close, are significant. And these implications occur very quickly because it's not as if the huge stocks of oil and natural gas liquids are maintained that can sustain a situation where the pipeline is closed for very long. On top of which, we can't move this product by truck or by barge. Certainly, if we tried to move it by truck and we had hundreds of fuel tanker trucks crossing the Mackinac Bridge, that would not make the Attorney General happy. It would not make us happy. It shouldn't make anybody happy. A pipeline is a much more efficient way of transporting the oil and a much safer way of transporting it. Likewise, rail is not available. All of that is explained in the affidavit of Bill Renicky, also filed with Your Honor on Friday and made available to the state at that time. So closing the pipeline translates to closed refineries in the US and Canada, closed facilities that produce propane, lost jobs, and all of the consequential economic dislocations that follow. If it were wintertime, we'd be talking in addition about people losing the propane they need to keep their homes warm, particularly in the Upper Peninsula of Michigan. But we don't know how long the injunction would last if this court were to grant the state the opportunity to impose its own safety regulation and conduct its own review. That it is indeterminate. They say 14 days. It's 14 days for them to do an initial look, but they're not saying that within 14 days the pipeline would be up and running. You've received amicus briefs from other jurisdictions that address these issues, that address the impacts to those jurisdictions. So the impacts go beyond Michigan, and that factors into the analysis as well. So the balance of harms fall in Enbridge's favor. We have basically baseless fear of a safety issue with pipelines that have operated safely for decades, balanced against actual harms within and outside of Michigan. The most safety enhancing end that can be reached here is for the state to stop litigating and to start supporting the tunnel agreement that they signed in 2018 to expedite the tunnel construction process, the permitting and construction process. We're paying for the tunnel, by the way, but the state has to permit it. The third agreement, executed by the state in 2018, provides that the dual pipelines can continue to operate until they are replaced with a new line in a new tunnel. The state agreed to that. But the state's lawsuit and its preliminary injunction motion are in direct conflict with the obligations it undertook in the third agreement. The state should process the tunnel applications in order to allow Enbridge to close the dual pipelines, replace them as soon as possible, and end this kind of litigation. But in any event, this court should deny the preliminary injunction motion, dissolve the TRO, and dismiss the lawsuit altogether for the reasons we've offered. Thank you, Your Honor.
Mr. Coburn, I'd like to, well, first of all, does that conclude the presentation on the Enbridge side?
It does, Your Honor.
Okay. So what I'd like to do, Mr. Coburn, if you don't mind, is I'd like to ask you a couple of questions on some points that you touched upon, because I think before we go back to Mr. Reichel as to any further comments he has in reaction to your statements and Mr. Hassler's argument as well, I think perhaps having you and I discuss a couple of these points might help focus that a bit, if I could.
Happy to answer your questions, Your Honor.
It appears that essentially Enbridge takes the position with regard to the ability of the state to take any action requesting that the pipelines be shut down pending something happening, further testing, further documentation, anything at all. It appears the state, or that Enbridge takes the position that the state doesn't have the ability to do that because of the complete federal preemption as far as regulation of pipeline safety. And my question is, how do you reconcile that position with the fact that the state actually does have some regulatory authority, some areas where Enbridge must go to the state to get authorization to do some things that in some way impact safety of the pipeline? For example, doesn't Enbridge have to go to the state to get authorization for installation of the anchors that we're talking about, that such as the one that was damaged.
Yes.
So how do you reconcile those two things, that the state has actually no role in anything related to safety of the pipeline because of the Pipeline Safety Act and FEMSA's oversight? How do you reconcile that with the fact that there are at least a couple of important areas where the state has some oversight responsibilities that actually directly impact safety of the pipeline?
Right. Let me explain our position on that, Your Honor. The screw anchors or the anchor supports that you're referring to, which we can install only if we get approval from the state. We need that approval because we are placing those anchors in the state-owned bottomlands, and in doing so, there is a risk of disturbance to the bottomlands. And so from an environmental point of view, the state controls any kind of construction of that nature, whether it was pipeline related or not. If we were in a different line of business, placing some kind of anchor on the bottomlands of the Straits of Mackinac, we would undoubtedly need some kind of a permit to do that. So it's
Example, if you were building a bridge, for example.
correct, or a tunnel for that matter. For the tunnel, which we want to build, we need the permission from the state because we're disturbing to some extent, we think a modest extent, the bottomlands. And the state regulates that for any kind of business. So that isn't pipeline safety regulation. That is the state's right, which we do not challenge, to control the environmental impacts on the bottomlands. Now, interestingly, in the case I alluded to before, where Mr. Bach made representations, that was a case in which certain groups that are opposed to the dual pipelines challenged as unsafe the installation of these screw anchors. And there, we moved to dismiss most of those claims on the grounds, among others, that those safety concerns were preempted by the Pipeline Safety Act, and the state agreed. And most of those claims were in fact dismissed. So I think that lines up precisely with the position that we're taking in this case. In fact, the Attorney General's position in that administrative case lines up exactly with the position we're taking in this case.
But there is some intersecting of the state ability to control what happens on the bottom lines. There's some, you may call it indirect, but there's some unavoidable intersecting of the state's ability to manage its natural resource in the bottomlands. There's some natural intersecting of that with safety, isn't there?
Not when it comes to operation of the interstate pipeline that Enbridge operates, no. When it comes to operation of the pipeline, that is an area where the federal government has said, we're going to manage the safety. We're going to manage it by ourselves, and we don't want states intruding. So yeah, sorry.
I'm sorry, Judge, you have to repeat yourself.
Let me put it another way, because I may have led you in a direction I'm not intending to go or have you go. Part of Enbridge's argument and dispute here with the state's position is that you're saying that the state initially in this case took the position that this was about location.
Mm-hmm.
And now is taking the position that it's about safety. You can't completely divorce location from safety, can you? Because the location is, in this case, the location is part of the reason that special safety measures need to be taken. Isn't that correct?
In the sense that the pipeline, because it rests on the bottomlands, and the bottomlands are affected by currents, and as Mr. Hassler explained, the spans can develop, then we have to have these supports for the anchor at certain points to maintain the spans so that they don't get too long. But that is a safety matter, which results from where the pipeline is, yes, where the pipelines are, but,
And it's part of, and it's
but
part
the
of-
regulation, I'm sorry,
And it's part of due care and operating, isn't it?
to maintain the spans, yes, but, or to limit the spans. But the determination of whether the pipeline itself is safe, the determination of whether it can be operated without risk of leaking or rupture, those are determinations that are strictly safety determinations. And those are the kinds of issues that the state is focused on. And they've acknowledged that. They've acknowledged that their focus is on the safety of the operation of the pipeline. That's where location doesn't matter. If they tried to do this anywhere in the state of Michigan, we would say they are precluded.
But I thought it was Enbridge's agreement, position with regard to this motion, that Enbridge does in fact have a due care obligation. Did I misunderstand that or get that wrong?
We're not interested in debating the due care obligation with the state. It's in the easement. We understand it. We believe that the only reasonable way of interpreting it to make it compatible with existing federal regulation is to interpret it to mean that our obligation is to adhere to PHMSA's safety regulations. Not
Okay.
that somehow it imports state regulations on top of those.
I'm not trying to debate that with you at all. So that leads me to my next question. If you agree that there is a due care obligation on the part of Enbridge, and you agree apparently that part of the determination of whether due care is being exercised is compliance with the safety imposed by the regulator, the federal regulator.
Mhm.
But apparently you agree with those statements at least, correct?
We agree that we have an obligation to comply with the federal regulator. I think that's what I heard you say, so certainly yes.
And you agree that that's part of determining whether Enbridge is operating the lines with due care. Do I understand that correctly?
I think that's probably all of the due care obligation. I think that's the only way of reading the due care obligation, so as not to read it to result in there being a diminution of the preemption. In other words, we do not read the due care provision to give the state any special rights that any other state doesn't have.
I'm not suggesting you do. I'm trying to get to what you argued and make sure I understand this part of your argument. Then I have some questions about it. That is, when you were discussing the due care obligation, I think it was you, although maybe it was Mr. Hassler, said that the fact that PHMSA said they had no objection to restarting the west line is in and of itself due care. In other words, it's proof that you exercise due care. I think one of you said that.
I don't know that I use those words, but I think that's true. Yes.
And one of you said, I think it was you, Mr. Coburn, that said that it is not as if Enbridge unilaterally decided to go ahead and restart the west line.
That's
And in
right.
fact, you got authorization from PHMSA, and therefore we have evidence, and in fact, indisputable proof that Enbridge is operating or restarting the west line was consistent with due care. Am I following you
That's right.
correctly so far?
You are.
Okay. My question, though, then goes to what exactly happened? And this is part of, as you know, what I raised in my opinion and order with regard to the TRO. What information, and I think it's part of what the state has been asking, what information specifically was provided to PHMSA
Mhm.
before they gave the no objection, go ahead and start, but do it in daylight with a boat out there? And I'm presuming, and I don't mean to make light of this, I'm presuming that means so that you can see if oil bubbles up to the surface when you start.
Right. Correct. So that's addressed in the affidavit of Michael Kobe.
Exactly.
KOB1,
That's where I'm
right?
going. I'm going to ask you
Right.
about that. If you want to turn to it, I can.
Sure.
Exactly where I'm going, because one of the things that has occurred in this case, I'm not faulting anybody about it. I think all counsel, at least counsel on the side of Enbridge, have referred to this.
Mhm.
As things started happening quickly, information has been developing over the last week or so, week and a half,
Right.
including, I guess, before we get to the West Line, I'll just note, including the whole list of things that PHMSA says, that PHMSA now says, as of yesterday, will be required before they will consider giving the okay to restart the East Line.
Mhm.
As you know, the public may not know, but as you know, none of that was outlined by PHMSA at the time that I entered the TRO. So it's only relevant for purposes of this preliminary injunction motion that we're hearing today. But at the time that I issued the TRO, PHMSA had not weighed in even on the East Line anywhere near the level of analysis that they have now, and that they are now imposing, that Enbridge put in place. But let's look at what they did with regard to the West Line, and the timing of what you are indicating was the approval, and I think are arguing that due care is evident because PHMSA undertook this independent evaluation and wasn't just a unilateral decision by Enbridge to restart the West Line. If you look at the Michael Kobe affidavit that you submitted on page 3, now this was alluded to in a very general way in Enbridge's response to the request for temporary restraining order, but it is more specifically identified in this Kobe affidavit. In the general way, there was a statement that PHMSA had, quote, no objection, close quotes, to restarting the West Line, but did have the suggestion of doing it in daylight and having a boat out there. That was the extent of the disclosure at the time that Enbridge responded to the state's request for a temporary restraining order. But now, in response to the merits of the motion for preliminary injunction, we have Mr. Colby's affidavit, and this, for the benefit of those who may not know, the attorneys know this, but the affidavit indicates he is the vice president of U.S. operations.
Right.
That he is tasked with the duty to ensure the safe and efficient delivery of energy products throughout the United States, according to his affidavit. Turning to page 3 of that affidavit, he addresses the interaction with PHMSA as things were developing in real time, essentially, to use that term. When PHMSA was being informed of what Enbridge was learning about the East Line and the West Line through its remote vehicle observations and the diver observations. Then there's this paragraph 17. It says, during the morning of Saturday, June 20, 2020, Linda Doherty, this is the person, the PHMSA representative who was involved at that point in interacting with Enbridge about what happened and possible restart.
Judge, you keep cutting in and out a little bit on the volume. If you could lean in a bit closer to your microphone.
Okay, will do. Thanks, Casey. So Ms. Doherty was involved with Enbridge in working with Enbridge to look at the information Enbridge had about the East Line discovery and also with regard to the West Line, and then discussion about what to do from that point moving forward. And it says that during the morning of Saturday, June 20, 2020, Linda Doherty informed me by email, me being Mr. Colby, by email that, quote, based on Enbridge's assurance that there are no issues or damage to the West Line, close quotes. That's not me quoting just from the affidavit. That's actually Mr. Colby quoting Ms. Doherty. Based on Enbridge's assurance that there are no issues or damage to the West Line, close quotes, PHMSA personnel, quote, have no objections to restart of that leg, period, close quotes. So isn't what happened exactly what you said? Well, let me phrase it another way. Where in all of that, and any information that has been provided to me or to the state, is it documented that PHMSA actually undertook some type of an analysis of what happened and what information Enbridge had about the West Leg, that PHMSA undertook any kind of analysis, reached an independent determination that it was okay to restart, and therefore would allow me to accept your argument that because PHMSA said it's okay to start the West Leg or West Line, ergo, it is without dispute that Enbridge is operating or would be operating the West Line with due care because PHMSA's blessing equals due care. I'm trying to figure out where the actual meat of the information is that tells me that, because Mr. Colby's quotation of what Ms. Doherty said certainly isn't that. All Ms. Doherty said, according to the quote, is that Enbridge assured Ms. Doherty there weren't any problems. So Ms. Doherty said, okay, no objections. Yeah, do you follow what I'm saying, Mr. Colby?
I follow what you're saying, Your Honor, and I'm going to turn the answer over to Mr. Hassler, who worked with Mr. Colby and who is a little closer to this issue. But I'll say this quickly before I do, which is that what happened on the West Line is very clearly did not hurt the integrity of the line, didn't injure the integrity of the line. It was a scrape of biota off of the line.
I'm not trying to debate. I don't want you to think I'm trying to debate that with you.
Yeah.
Or challenge you on that statement. What I'm trying to do is follow, as you can probably appreciate, one of the things that I'm trying to get to is Mr. Reichel's part 2 of what they're asking, and that is that I look at and consider an injunction until the point that Enbridge demonstrates that they are operating the west line, or will if I say go forward, that the west line is operating as a reasonably prudent person would, using the language from the second agreement and the easement. And your argument was, well, we know that automatically because PHMSA, it wasn't Enbridge who unilaterally made the determination that it was safe. It was PHMSA. And I'm just trying to find where is that information, because it's not in the quote that Ms. Doherty said and is quoted by Mr. Colby. And I think we still don't have that email exchange, if I understand Mr. Reichel correctly, but he'll address that in a moment. So fair enough, though, Mr. Coburn, that we'll turn to Mr. Hassler since he worked on the facts of this with the applicant.
Thank you, Your Honor. And Your Honor's question about what it is that PHMSA had before it on that Saturday, the 20th, in many ways relates to Your Honor's order of June 25th. That is, Your Honor granted a TRO based on the exchange you see here. In terms of the preliminary injunction that we're now addressing.
I didn't have that exchange. This exchange is new. The quote from Ms. Doherty that says, quote, based on Enbridge's assurance, I don't think that was in any document that I was presented in response to the request for the TRO. I think what was presented was we got, quote, no objection, close quotes, we being Enbridge, that is, got no objection from PHMSA, and so we restarted the West.
That's right. That was the part there. And the point I was going toward, Your Honor, is that arguably from Your Honor's point of view, the TRO was justified because you did not have information before you that gave the assurances you were seeking, as you stated in your order. On the other hand, in terms of the preliminary injunction today, there is additional information that PHMSA has looked at the West Line. If you look at the PHMSA letter of June 29, they specifically say they have reviewed the ROV video. And I should. Looking on page 1.
Go ahead, Mr. Hassler. I have it in front of me.
Yes, Your Honor. At the bottom, it says that PHMSA has reviewed the video of the ROV, so they know what the feature looked like, as well as other technical information. That would have included the assessments that were provided. I believe the first one went to PHMSA on June 21st. I believe the revised version went on the 24th. They had all that in front of them when they issued this letter on the 29th.
If it went on the 21st, it was after the point in time where Ms. Doherty said, based on Enbridge's assurance, go ahead and open the West Line, because that happened on the 20th.
I agree, Your Honor. That's what I'm saying, that to the extent Your Honor ruled based on what PHMSA knew when it made the decision on Saturday, your TRO is not affected by this additional information.
Okay.
On the other hand, in terms of what we're addressing today, which I take is whether the West Line should continue to remain shut, PHMSA has quite a bit more information before it at this point, and they have opined that they believe operation is safe based on their own review of the ROV, based on the technical information that Enbridge provided. That's clearly all in front of them, Your Honor. And so they are opining in an informed way. It wouldn't surprise me, Your Honor, if PHMSA didn't read your ROV. And as a result, excuse me, I said ROV, I meant TRO, forgive me.
Well, I can tell you they probably did, because somebody from PHMSA contacted my law clerk, Ms. Smith, immediately or soon after it was issued and asked for a copy of it.
I did not know that, Your Honor.
So I'm assuming they read it.
I assume so too, Your Honor, and I assume they documented. Your Honor indicated you wanted to have documented what PHMSA had considered, if I remember the TRO correctly. And here they document in this June 29 letter that in fact they reviewed the video footage. They document that they have viewed the other technical information, and that their conclusion is that there is no indication of a safety-related concern.
can you address, while we're on that part of the letter, can you address the issue that Mr. Reichel raised about the state not being provided with the email exchange between PHMSA and Enbridge that is referenced in that letter?
We can provide that, Your Honor. I'm happy to do that. Or, excuse me, Mr. Coburn has something to say on that.
Well, let me just direct Your Honor to another affidavit that we submitted, that of Dave Stafford, another Enbridge official who was involved and who routinely deals with PHMSA. If you look at page 2 of his affidavit, he says, based on my cell phone records, I have had at least 14 phone calls with PHMSA during the relevant time. This is in addition to that. This is on the bottom of page 2 in paragraph 8. In fact, in paragraph 7, he talks about 54 communications from PHMSA in the 7 days since the discovery of the damage. But these communications include, it's 6:59 Central on Thursday, June 18, he contacted Harold Winnie at PHMSA, alerting the agency to the moved screw anchor and asking him for a meeting. The point here being that, and it goes on to describe these communications, that there was lots of back and forth between Enbridge and PHMSA at the time.
I noted that as well, Mr. Coburn. But I also noted that there really is not, other than under paragraph 10 of Mr. Stafford's affidavit, there really is not a reference to the West Line other than in that paragraph indicating that Michael Colby contacted Alan Marbury and Linda Doherty of PHMSA, advising them of Enbridge's desire to reopen the West Line. And then there's a reference that talks about Mr. Stafford saying in his experience, if PHMSA had believed, he doesn't refer to anything that PHMSA actually said or looked at or reported back to Enbridge. He says, in my experience, if PHMSA had believed that the West Line was unsafe to operate, PHMSA would have directed Enbridge to not restart the line. But all of that sort of sidesteps the question that I have, and that is, what was PHMSA relying on to say, okay, to restart the West Line, other than Enbridge's unilateral determination that it was safe to do so? Now, Mr. Hack just pointed to some of that that happened, since that exchange on the 20th. So, but that's the point of my question. Mr. Stafford's Mr. Stafford's affidavit doesn't really address that any further, other than indicating that on Monday, June 22nd, he emailed Enbridge's latest integrity assessment of the West Line to Ms. Ox, and then he goes on to make the conclusion that I'm assuming PHMSA would have said something had they been concerned. But I think it's pretty clear from reading all of these affidavits and the exchange, I should say, between PHMSA and Enbridge. Everybody was focused on the East Line, and the West Line was a little bit of an afterthought. Now, you may argue that's because it's so much of a lesser issue, and I get that. I'm not trying to challenge you on that. I'm just trying to figure out what PHMSA had to make these conclusions that it's okay to open the West Line, and if I can rely then on your statement, since Enbridge wants me to say no preliminary injunction as to the West Line because we're operating with due care. We acknowledge we have a due care and reasonably prudent person standard or duty that we owe to the state, but we have proof that we've complied with that because PHMSA said, okay, operate the West Line. I'm just trying to find where is the substance in between that. So I think Mr. Hassler tried to answer that to some extent, pointing to the reports that were ultimately sent. But that leads me to another question, and I'm going to probably, I assume will be for Mr. Hassler, but if you want to weigh in, Mr. Coburn,
Okay.
I don't have any objection to it. One of the things that I guess continues to at least cause me some question is why PHMSA, if they did such due diligence in looking at what to do about the West Line and whether it was safe to operate, why did PHMSA not recommend any type of testing to confirm the initial conclusion and perhaps arguably reasonable conclusion from the divers in the remotely operated vehicle that the area of the missing biota was not anything that damaged the integrity of the line. And the reason I ask that question is, if you look at Enbridge's own affidavit, Mr. Maxwell's affidavit, he says there should be an inline inspection. You know, folks have talked about, Mr. Hassler called it looking like a torpedo shaped device that's put in. But even Mr. Maxwell
Get your mic.
says to undertake that testing. And in fact, I don't know if I should take this, I don't want to be too thin-skinned about it. I'm not going to take this as a criticism, but Mr. Maxwell says, well, geez, we were getting ready to do this safety testing and then you shut us down. I'm not sure that's quite accurate because I didn't issue the TRO until early afternoon on the 25th, and Mr. Maxwell's affidavit says, well, we were all set to do this testing on the 25th, but you shut us down. Well, I don't understand when it was going to happen if you didn't start by 12:30, 1 o'clock on that day. But be that as it may, let's set that discussion aside. Let's look at the issue of inspecting. What PHMSA actually looked at, what Maxwell is recommending, and then the suggestion that Enbridge has that if you authorize the restart of the line, at least for the testing, we could accomplish what we were planning to do on the 25th of June.
Certainly, Your Honor, and I won't, if Mr. Coburn could mute his mic. Your Honor, I won't dwell on this, but I will make clear, no criticism, direct or implied, of Your Honor's order was intended by the statement about the ILI. It was meant to be purely factual, that the court was, that we complied with the court's order. As I indicated before, ILIs have to be scheduled many days in advance, sometimes weeks in advance. So we were trying to do an ILI, not because we thought the line was injured, but because we thought we would face skepticism, as frequently happens in this case, that perhaps we hadn't confirmed that the line was safe. So this was a belt and suspenders approach, Your Honor, that it's, if you talk to the integrity engineers, they think the idea that the only damage is to the surface of the line makes clear that it's safe to restart and that you don't need to go further. On the other hand, I think they rightly anticipated that there would be controversy here simply because it's the Straits. And so they were going to go the extra mile and do additional testing, not because it was unsafe, but because they wanted to make sure there was no doubt that everyone knew that it was safe. Similarly, Your Honor, this goes to, even though the line was restarted on Saturday morning, I believe they had divers going down even after it restarted, not because they thought it was unsafe, but because there were measures they wanted to look at in terms of whether there would need to be future repairs. That when it comes to pipeline safety, the line can be safe to operate today, it can be safe for years. But if, for example, there's bare metal, corrosion can begin today, and over years it can degrade the quality of the line. So what you want to do is, if you see a patch of bare metal, you want to coat that and repair that so that 2 years down the line, you don't have a corrosion problem. So what I'm saying is, Your Honor, it can be safe to operate today, even with bare metal. But you want to find the bare metal as quickly as you can, immediately, even while the line is operating, so that you can do preventive maintenance to prevent a problem in the future. Does that answer your Honor's question?
In part it does. So why wouldn't PHMSA have looked at, you said there was some internal dispute within Enbridge as to whether the divers saw bare metal or was perhaps a reflection of the artificial light necessarily used at diving at those depths. Why doesn't PHMSA, don't they look at that issue and make their own determination? They always just take Enbridge's determination, or what happens?
It's not that at all, Your Honor. It's that from a point of view of whether the line is safe to operate, which is what PHMSA is focused on. It's safe whether or not there's bare metal exposed. If what you have is a scrape on the outer part of the line, if there's not a gouge, if there's not some missing metal, if there's not a dent, that's what they're looking for.
And
what PHMSA would look for.
Wouldn't the inline inspection tell you if there was a dent? That's how I understood.
Yes, it would, Your Honor. Now, a diver, though, can look and see if there's a dent, at least to a certain degree.
There's a lot of line to inspect.
No, we're just looking at the area, the 70 square inch area, the patch at the west line. They're not, the divers aren't looking at the whole line. They're looking at the point of impact where the cable or whatever it was went over the line.
But they can't always see a dent, you're saying.
Well, if it's of a certain size, they can. And so if it's a big dent, you want them to find it quickly and they look. In this case, there was none visible. So whatever dent, if there is a dent there, it would be smaller. On the other hand, the ILI devices are capable of detecting smaller dents. And so the ILI could either confirm there's no dent, or it could indicate, well, there might be a small dent. And then there would be further analysis, if that's what it's shown, of, well, is this dent a problem? Do we need to do things? But it would not be an immediate problem.
Then following up, Mr. Hessler, on something else that you covered in your presentation, you said that when you were talking about Mr. Miller from the state perhaps not realizing what information he had, or there being some oversight or missing some part of the information, that he had the information of the ILI from the west line from January 2020. Is that correct?
Well, he had that, but he also had other ILIs, Your Honor, if I didn't make that clear. That was the one I showed you. I'm sorry, Your Honor, I couldn't hear.
Going back further in time, you also said.
Yes, the January 2020 ILI is the most recent that I'm aware of. Right. And then we've given him, as far as I know, every ILI going back to 1998. Not him, but we've given DNR.
But as to this question of the integrity of the line and what PHMSA may know or what might be reasonably prudent on the part of Enbridge, if I understood you correctly, all of the information, even assuming the state received all of the CIS, the ILIs, everything up through January 20, if I understood you correctly, that still, and even the cathode testing that was done, which is part of the CIS, I guess. If all of that is correct, if I understood you correctly, Mr. Hassler, there still could have been, this damage still could have occurred to the west line after all of that happened, right? Isn't that why Mr. Maxwell himself is recommending an ILI?
The incident that knocked the aquatic material off the outside of the line could have happened after those tests, no question. So they're not dispositive, but you want to look at them too. You don't want to miss anything. So from an integrity point of view, Your Honor, if Mr. Maxwell were here and we can make him available, that the superficial, excuse me, I won't say superficial, I'll say the minor impact on the outside of the line does not threaten the safety of a line that is 13/16 of an inch thick. That is a conclusion that the engineers all feel confident about, that they believe you can make that conclusion based on the ROV alone. the fact, and it's ironic that the fact that they went beyond that to be double sure and triple sure would be held against them, when in fact they could have concluded it.
The ROV only looks at the top of the line, correct?
Well, that's where the impact was, yes, Your Honor.
But that's,
This ROV, Your Honor, you can look on the sides. This ROV, though, is what they call a single pass from the 12 o'clock position over the line.
okay.
So yes, now you can observe under the line, but I think Mr. Maxwell would say that in the vast majority of cases, if there's any impact on the line, it's going to be on the top, not the bottom. So, you know, a cable or some other object didn't go under the line, it went over the line. That's why you look on top.
Your Honor, can I add one other point?
Mr. Colburn, sure.
Thank you. So when this absence of biota on the surface of the line was discovered, I think it's fair to conclude that the Enbridge engineers who manage this line day in and day out, they know these lines, and the PHMSA engineers learning about this situation understood that this was not a situation that gave rise to a safety concern. In fact, Enbridge was under no obligation at that point to even close the line. It did it as a precaution because it wanted to understand what happened here. This was a somewhat unusual event. On the other hand, there are times, and the state is well aware of this, there are times when patches of coating get displaced from the line for one reason or another. For example, sometimes when a screw anchor is installed on the line, that work can lead to small patches of coating being displaced. One could say that that's somewhat more serious than here, where the coating is apparently intact and just the biota, which serves no protective function at all, is scraped off the line. So I think it was and we don't stop the line. As a matter of routine, Enbridge does not stop the line every time a patch of coating is lost, because they know from experience that that is not a safety issue. They fix it. They fix it under a well-established protocol, and they fix it as quickly as possible, but it's not an urgent safety issue. Likewise here, I think it was understood that we didn't have an urgent safety issue with the West Line, and we still don't. Yes, because these pipelines are closely monitored. We go above and beyond. We go above and beyond to do the ILI, to speak to PHMSA, to let them know. But it's not as if PHMSA had to spend a lot of time deliberating once they learned the facts.
Well, maybe not, but what I'm trying to find is where do we see that they receive the facts? For example, is there somewhere that shows, and I think it goes to what Mr. Hassler and I talked about earlier, where does it show that PHMSA looked at, and what you just referred to as engineers at PHMSA making a determination, where is it shown that they looked at the cathodic protection and coating measurements to the West Line that the divers took, and that the engineers made some determination, the PHMSA engineers made some determination from that? Again, getting to my point of, if you're going to rely on PHMSA's determination or no objection, quote, no objection to restarting the West Line as proof and evidence that Enbridge opened or restarted the West Line as a reasonably prudent person would do and with due care, where is that? That's what I've been trying to ask. And maybe some of it's in that email, Mr. Hassler, that you said will now be produced.
No, Your Honor, I think we tried to accurately reproduce the email in the affidavit. We didn't spin it. We wouldn't have put the language in there that we put in there I mean, we can make it available, but it's going to say, in effect, what's in the affidavit. What I was going to say, though, Your Honor, is if we move away from the Saturday restart to today, to the question we're looking at today, what does PHMSA have available today when it opines? PHMSA has quite a bit. Excuse me one second. First, it has both the June 21, it's Maxwell Exhibit 3B. It has Maxwell Exhibit 3C. That includes the cathodic protection information. That includes the review of ILIs. That includes, and in addition, PHMSA has actually reviewed the ROV data. It has all of that. That's all in the letter dated June 29. And PHMSA has concluded, based on all that evidence that it has reviewed, that it's safe. Now, Your Honor, I don't work for PHMSA. I can't go inside and ask them for a certification. But the letter that we got is pretty clear that they considered all of that information, that it was available to them, and that they found it reasonable to restart and safe based on that. I mean, Your Honor, we're getting in a situation where the state has the burden here to get an injunction to close the line. And somehow it seems like the burden is now on us to prove that PHMSA made the right decision, when it seems to me PHMSA made an objective, neutral decision by an expert regulator.
Okay, thank you, Mr. Hassler. Mr. Reichel, I'll give you a chance to respond to the arguments of Mr. Hassler and Mr. Coburn, and then I may have some questions for you as well. Hey, Casey, you're muted, Mr. Reichel. Hold on.
I apologize. There are many arguments, both specific and general, that have been advanced by counsel for Enbridge, not necessarily in order of importance, but I want to dispel something. I believe it was Mr. Coburn who spent a considerable amount of time saying, well, the state didn't, or excuse me, the Attorney General didn't file a motion for preliminary injunction back in June of 2019. So why are they doing it now? There's a very simple answer to that. It came to the state of Michigan's attention on June 18th that Enbridge had detected what it called, quote, significant damage, at least to the east leg, that was sufficiently concerning that, as counsel noted, that they shut both pipelines down to scrutinize it. Over the course of that weekend, as reflected in the record, I'm not going to go through it, there was an exchange of correspondence, not between the Attorney General, rather the governor of the state of Michigan, and the CEO of Enbridge, expressing concern and requesting information. And it was in some of that correspondence that the governor, working in conjunction with two agency heads of DNR and Eagle, among other things, asked for the data, asked for electronic information within 24 hours. That was not something that the Attorney General just made up. And to be clear, it wasn't actually part of our motion, either the TRO or the present motion for PI. I think it's important to contextualize this because Enbridge seems to want to question the seriousness or the circumstances under which the Attorney General took the unusual step of seeking both a TRO and now a preliminary injunction. That's the context. There was something that, at least initially, and I submit still today, unambiguously with regard to the east line, that was sufficiently concerning that Enbridge shut both lines down. And I think, for the reasons we've advanced earlier, I'm not going to repeat my arguments, but that the state felt it was appropriate and necessary for them to ask Enbridge to immediately provide them with all the relevant information. And it was against that background that the Attorney General, on behalf of the people of the state, which includes the governor, filed both the TRO motion and the PI, which brings us here today. Again, I apologize for the somewhat disjointed nature. I'm just looking at my notes. With respect to this whole issue of Enbridge vociferous contention that PHMSA and PHMSA alone has any authority to direct Enbridge what to do, or even direct's not the right word, to be involved in or oversee the operation of Line 5 in general, of the Straits Pipeline in particular, it's interesting to note, as Enbridge has acknowledged, and I assume the court is aware just from looking at the papers here, that Enbridge was sued by the federal government, the Environmental Protection Agency, as a result of releases that occurred in 2010 elsewhere in its Lakehead system. And the long and the short of it, those claims were resolved by a consent decree, not between PHMSA and Enbridge, but EPA, under which the consent decree was entered and has been modified multiple times, and this was alluded to here, under which the EPA, not PHMSA, has established highly prescriptive standards for various activities. For example, mandating more frequent inspections than apparently PHMSA would necessarily direct or require. Reducing the spacing, being heavily involved in where these anchor supports are going to be installed. I don't want to get far afield on this, but I think the fact that another federal agency that focuses not on pipeline safety, but environmental protection, and ultimately a federal court, has taken jurisdiction over and is directing Enbridge to make certain modifications in its operation of Line 5, wholly outside of the purportedly unique role of PHMSA. Again, I don't want to belabor that further, but I think it's important to understand that it's not quite as simple or sweeping as Enbridge would have the court believe. With all due respect to Mr. Hassler and his, quote, revelation about what he describes as an error in Mr. Miller's affidavit, I would just like to set the record straight. If you look at Mr. Miller's affidavit, there are two parts of it that are relevant to this question. Paragraphs 7 and 8, Mr. Miller described what documents he reviewed. And again, let's put this in context. He was asked to review various affidavits that Enbridge supplied to this court and the plaintiff last Friday. And he did that over the weekend, and he recited what he looked at. He listed a series of affidavits, and he also listed, he indicated that he had looked at ROB footage. And with respect to this issue about the underlying inline inspection data that Mr. Hassler says dramatically, oh, well, the state's had it since January. I mean, if you read what he was looking for in paragraph 18, he said, if Enbridge is going to rely on this correlation between the ILI data and the observations on the surface of the pipeline, they should provide recent ILI data with designations of those data with designations about the relevant areas. In other words, and that wasn't provided. I mean, Mr. Miller was reviewing the various technical reports attached to the Maxwell affidavit, and he said what he looked at, and to suggest that he should have gone out and contacted the director of the Eagle or DNR to see what they had in that compressed time frame, I don't think it's fair. In any event, to some extent, this is a collateral issue, but I do think that it's important to understand what specific information Mr. Miller was seeking that he said wasn't reflected in the reports that were available to him. And that is not just raw ILI data, but ILI data that, if, as I read as a layperson, read these engineering analyses, the Enbridge engineers said, well, we looked at where we see these feature on the line, and we correlated that to historic ILI runs at a particular location, where these tests were run. As Mr. Hassler explained, these are enormous piles of data that are run the entire length of the pipeline. So the point of Mr. Miller's comment, and indeed is part of our request, is to provide the data underlying the conclusion expressed by engineers, which is that if we correlate the inline inspection data or the cathodic protection data with these particular locations, we don't see a problem. So I think it's important to clarify that factually. with respect to the issue of what impacted the both the East and West pipeline, the conditions that bring us here today and that were discovered or disclosed just within the last couple of weeks, Enbridge is saying, as I understand it, that their engineers believe that whatever hit each of these pipelines, and they hypothesize, as Mr. Hassler explained, that something, they don't know what, a cable line, something or other, was dragged in an east-west direction and impacted both the east and west line, resulting in this feature that we've been discussing on the west line. But that, quote, it was a light impact. And secondly, with respect to the feature on the east line, the E17-1, the anchor structure there, they say, well, we know it was not a big deal because, well, I'm sorry, they didn't say that. What they did say is that they can infer that whatever hit it was not a vessel anchor that would cause damage to the pipeline itself or something close to that. And so while Enbridge, both in its papers and its argument here today, has emphasized these additional measures that it's put in place to guard against anchor strikes, including the coordinated system that is described in the affidavits, they appear to acknowledge, or at least there's no dispute, those systems didn't prevent the impacts that affected both the east line and the west line here. They seem to be saying, well, it doesn't matter because they're not designed to do that. I'm not clear exactly where Mr. Hassler ended up on this, but the gist of it seemed to be anything of real concern is going to be addressed by these mitigative measures they have in place now. And with all respect, I don't think there's a factual predicate for that. And more fundamentally, I think the court can and should take notice of what to me, and I think any reasonable person, would be an alarming phenomenon, that apparently the lines can be struck repeatedly from some unknown and undetected activity that simply is not going to be detected contemporaneously. They don't know when it happens. They're down on the line for some other purpose and they see it then. And they don't know what is causing this. And it appears today, the inference from the available information, is that these mitigative measures dealing with large anchor strikes apparently don't address them. And to me, it is an unreasonable situation and inconsistent with the due care obligation to have in place a situation where external objects can hit these pipelines and damage them to one degree or another. And even if it's not a full anchor strike like that occurred in April of 2018, Enbridge can't either detect them when they happen or prevent them from happening. So, again, on the issue, the case law on preemption, as I noted earlier, and as Mr. Coburn or Mr. Hassler both pointed out, some of the legal issues on that have been the subject of their supplemental brief. We will be filing our response to their supplemental briefs shortly. I mean, I can address their cases today if you want, but
Judge, you are muted.
Mr. Reichel, you don't need to address those cases. It's my understanding it's going to be brief. So
that's fine. I appreciate it, Your Honor. I realize I don't want to take too much more of the court's time, but I want to, if I may just continue to briefly check my notes.
Go ahead. Don't worry. I'm here as long as you need to be here.
Thank you, Your Honor. With respect to the court's line of inquiry to Mr. Hassler and Mr. Coburn, about PHMSA, I think the court appropriately raised some questions. I mean, about exactly what PHMSA did and how. This is not, I understand, this is absolutely the plaintiff's motion for preliminary injunction, and this is not an investigation of PHMSA. But I think, as the court astutely observed, part of Enbridge's argument seems to be that, although they, to me at least, equivocate on what due care obligation we acknowledge, but they seem to concede in response to your question that, from their perspective, so long as PHMSA has passed on a particular issue, made a specific determination about the integrity of the pipeline, that should end the question. That establishes compliance with the easement standard of due care. But as your questions pointed out, I mean, this is all unfolded rapidly, but it seems pretty clear, based upon the limited information we have, that when Enbridge first indicated to PHMSA last weekend, not this past weekend, but on the Saturday, that they were planning to restart the West Line. And what was filed initially by, and even to date, by Enbridge on that subject, simply reflected PHMSA saying, based on your assurances, that is Enbridge's assurances, we PHMSA do not object. There's no indication that when it did that, that it had actually, what data, if any, it had reviewed, what sort of independent analysis it had taken. And while Mr. Hassler correctly notes that the letter that was received yesterday from PHMSA, which addresses both the East and West Line, the East Line in considerably more detail, does indicate or represent that PHMSA has, quote, reviewed Enbridge's submissions and the ROV files. I mean, I'm not questioning the truth of that statement. It is what it is, but it's interesting as to when that occurred. It appears to have occurred only after there was considerable public scrutiny and concern expressed by the state of Michigan, the governor of Michigan, and certainly the Attorney General of Michigan. And apparently, and this is fine. I mean, it's entirely appropriate that PHMSA finds out what is going on in this case, as they apparently did. But it seems a little odd to me that it was only after the court issued its TRO, which raised, in my view, entirely legitimately questions about what had transpired, that PHMSA then said to Enbridge, well, we have now looked at the data and independently, they didn't actually say independently reviewed it, but I think the significance of this is that, as a blanket proposition, that PHMSA non-objection establishes compliance with due care, I think that is empirically open to question. One minor thing, but I can't ignore this. We touched on this in our reply, but Enbridge has twice, both orally and in its papers, sought to make a big deal of certain statements made by Mr. Bach in an administrative proceeding involving a third-party challenge to permits issued by the Michigan Department of Environment, Great Lakes, and Energy to authorizing the installation of additional anchor supports. And as we noted in our papers, and I'll just leave it at this, this is really taken out of context. The context there was the petitioners were arguing that the state agency, EGLE, should be making safety determinations about these support structures. And the substance of the argument by Mr. Bach in representing that agency in that proceeding was simply that, well, EGLE does not have authority to regulate pipeline safety. PHMSA does. It had nothing to do with the question that is before the court today, is what independent obligations Enbridge has to the state of Michigan based upon the 1953 easement to exercise due care. So I don't think it's at all probative, and certainly does not reflect some inconsistency in the Attorney General's position here. With that, I would be happy to respond to any questions you may have.
Mr. Reichel, assuming what Mr. Hessler indicated is correct, that lawyers should be able to work out what the document exchange should be, now that both parties have fully tried to evaluate what documents are available and documents that keep becoming more available as the days go on here. And you have presented in your motion, particularly in the reply to Enbridge's response to your motion, you indicated that you're not asking that either line be shut down for the rest of this case or any lengthy period of time, but rather what the state wants is 14 days to receive documents and have a chance to evaluate those. So assuming Mr. Hessler is correct, and I'm going with his review of his career history, I think we've all found this over time that we do realize that with a little work, lawyers can work out at least document exchanges oftentimes. What happens after 14 days? Let's say I were to agree with the state that you've met all the 4 prongs necessary for a preliminary injunction, even a short-term one, and that you have made the case under those 4 prongs for receipt of this additional information, and that all of you are able to work out what the parameters of that information is. What happens then? I know the second part of it is that you have asked that Enbridge provide a determination as to what struck the lines and demonstrate that they're acting as a reasonably prudent person would do. In other words, comply with the language from the 1953 easement and the second agreement. But isn't that where the rub comes in at that point in time? What are you asking that the state be allowed to do at that point? Take your issues to PHMSA and say, hey, look at this information, or further argue that they're not acting in a reasonably prudent fashion? What would you propose after 14 days?
Well, 2 things. Just to be clear, we refer to the 14 days, which was a period of time within which we believe people working for the state could complete their review of this additional information once it's provided. So that's where that comes from. And quite frankly, we were trying to offer the court, and for that matter, Enbridge, some assurance that the agenda here is not, as Mr. Coburn suggests, to, through some pretext, keep the line permanently shut down or indefinitely shut down based upon this incident. I want to say this one more time, Judge. There's a distinction between the underlying issues in this case, where we, as you well know, we're seeking the permanent shutdown of Line 5, and what's involved here. Little less than 2 weeks ago, this event occurred that was significant enough to prompt a shutdown. So what we are seeking is full disclosure of the relevant information so that people working for the state can look at it and form an informed judgment as to whether under those circumstances, given what is shown about the condition of the West Line and what caused it, that it would indeed be reasonably prudent to restart it. And the way we put it is that we believe that the test will be whether Enbridge in these data have shown affirmatively that the impact that occurred or were discovered to the West Line on the 18th or 19th are not sufficiently significant to warrant continued shutdown. But we are looking, in a nutshell, for the facts underlying that conclusion and an opportunity to independently review them. And we are requesting that some limited period of time be allowed for that to happen before Enbridge restarts.
What if it can never be determined with certainty what struck the lines? What do we do then? What are you asking the court to do at that point in time? What if Enbridge does whatever it is that they will do in addition to what has been done so far, and where they end up is, it looks like it was a cable of some sort, rather light in material, not an anchor that struck the west line because of the lack of damage, because of the pattern on the lake bottom isn't consistent with the way an anchor drags back and forth. And that's what they reached the conclusion of. And then as to the east line, they reached the conclusion that it was a medium-sized vessel anchor, most likely, and not a freighter because of the direction that the larger vessels go, and all of the things that Mr. Hassler, Mr. Coburn outlined, and PHMSA gets all the information they want, and they say, good to go. What happens then?
With respect to the east line?
Yeah.
Well, as I understand it, Enbridge has committed itself here today to concurrently provide to the state the information, the quite detailed information that PHMSA has asked them to on the same time schedule.
I think so.
Yes, and so the short answer is that the state would have the opportunity in real time, concurrently with PHMSA, to see these relevant data, indeed that PHMSA itself believes are relevant, to look at them, and so that if PHMSA ultimately determines, based upon, or at some point determines based upon those additional data, that it would be, quote, they wouldn't use these terms, but in our frame here, that it would be reasonably prudent to restart, then I think unless the state could demonstrate some fundamental flaw with that conclusion, technically, then I think that would be very probative evidence of meeting the due care requirement.
What about as to the west line?
Yeah, as to the west line, I believe Your Honor raised the question, what if they can't determine definitively what caused that? That is certainly a fair question, given the uncertainty about even exactly when this happened. I think what we're looking for, if in fact, it was suggested that a root cause analysis would take too long to accomplish, the substance of what we are requesting is that Enbridge provide as full of an accounting as they reasonably can of what caused this, so that the state could be in a position to conclude, as Enbridge apparently has, that it would be reasonably prudent to restart. And again, we're not looking for an extended period of time. We want the particular information we requested, a reasonable opportunity to review it, and to form a conclusion on that. And it may well be, I can't determine that without the information, it may well be that the state would determine that under the circumstances, it would be, quote, reasonably prudent to restart. And I would say that if for some reason we reached a different conclusion after having the opportunity to look at these data, then I readily concede it would be incumbent upon us to justify factually any further or any continued suspension of operation.
All right. Mr. Hassler, is it a reasonably prudent thing to do to run the ILI in the west line?
It's prudent in a belt and suspenders sense, Your Honor. That is, we think it's already demonstrated that the line is safe. PHMSA has agreed with us as of June 29th. There is no evidence in the record that disputes that. We would be happy to run an ILI. The line's going to have to be open to do that we would get the results to everyone. But I need to tell you, Your Honor, ILI results, you don't read off of a screen. It takes weeks or longer to get the results. They have to be analyzed. So that would be confirming. It would let everyone know, but that should not be a prerequisite to restarting a successful ILI. I have to say, Your Honor, what troubles me most about Mr. Reichel's argument is this. Mr. Reichel says he's troubled that you don't instantaneously know that there's damage, that it seems to him that this is dangerous. He made several points like that. There is not one iota of evidence in the record, Your Honor, that it is dangerous. The state has produced no expert testimony to say it is dangerous. The state has produced no expert testimony to say that the West Line is not safe to operate. That the state has, around the edges, tried to pick at, well, PHMSA didn't have the right information on June 20. They have not said that PHMSA did not have the right information on June 29, which was yesterday, which is what should be the basis of Your Honor's opinion. So Mr. Reichel, his argument that, gee, if they don't instantaneously know something hits the line, it must not be safe to operate. I understand that's his opinion, Your Honor, but that was equally true the day the Attorney General filed suit. I assume that was Mr. Reichel's opinion. In 2018, when the state signed an agreement saying that they thought that the lines were safe to operate based on what they knew, Mr. Reichel helped write that agreement. Right? Mr. Reichel had the same opinion then, perhaps. Basically, Mr. Reichel saying you can shut down the line based on a lawyer's opinion without any evidence or proof. Your Honor, we've provided affidavits, we'll provide witnesses, but they should not be allowed to escape their burden for shutting down the line when the line is safe. And I apologize. I'm worried that I'm offending Your Honor, but
You're not offending me.
But I feel very strongly that if they want to put on evidence that the West Line is not safe, that's one thing, but they have not done that. That if they want the full accounting, I think that's what this case is going to require sooner or later, and we have no problem giving an accounting, but the line should not be shut while that is being done, because there, as Your Honor was pointing out in your questions to Mr. Reichel, there will be one delay after another as the quote accounting is done. If the state had proved the line is not safe, that's one thing. They don't. So long as it is safe, it should be operating or be allowed to operate. I should note, Your Honor, you should not overreact, or excuse me, not you, but one should not overreact to the idea the line is shut down from time to time. For example, anytime wave heights reach a certain height, Enbridge will shut the line down under an agreement with the state. That doesn't mean the line's unsafe. It means through prudence and through agreement with the state, we will do that. Here, we made the decision to shut down, not because we thought it was unsafe, but because at that time, we thought we need to look further to make sure it is safe. We have looked further to make sure the West Line is safe. PHMSA has looked at it, and it is. There's no evidence it's not, so it should restart. That's what we are proposing. That notwithstanding Mr. Reichel's skepticism, that's not evidence, Your Honor. I don't know if Mr. Coburn has anything to add.
I do, if it's okay, Your Honor, just one or two quick points. Just so there's no mistake about our position on the due care provision of the easement. We read that provision as basically saying that we are obligated to adhere to PHMSA safety regulations. Those are the governing safety regulations.
Well, hold on, Mr. Coburn. I have a question about that.
Please.
That couldn't have been the original intent because PHMSA didn't exist at the time, at least the 53 agreement was put in
Yes.
place. It could be as to the second agreement. So I'm just trying to follow what you're.
I understand exactly what you're saying, Your Honor, and you're right. In 1953, PHMSA didn't exist. That wasn't what the agreement intended at that time. But then the Pipeline Safety Act came along, and it preempts states from regulating, and PHMSA started imposing an extremely extensive set of regulations that govern every aspect from construction to operation to testing to et cetera, relative to pipelines. And that became the industry-wide standard for interstate pipelines. And it can't be can't be, Your Honor, that somehow we agreed or that the state could continue to regulate as it might have done in 53 and 54 and so forth. That can't be right, because the goal of Congress in the Pipeline Safety Act was to get states out of that business, to establish PHMSA as the regulator. So the only way that the due care provision can remain in effect and remain meaningful is for it to be effectively the equivalent of, we will adhere to PHMSA regulations, and if we don't, that's not due care. And so to the extent the state is reading much more into it, that reading of the due care provision is preempted. Any reading that goes beyond the PHMSA regulations, I would submit to you, is preempted, because the state simply can't regulate. That is crystal clear. Now, as to Mr. Reichel's point about EPA having a role, that's true. We did. I was at the table, so was Mr. Hassler. We negotiated a very sophisticated consent decree with EPA arising out of the incident in Marshall, Michigan, having nothing to do with Line 5. And EPA did impose various requirements that are, in some cases, above and beyond what PHMSA requires. But that was done with all parties understanding exactly what PHMSA required, with PHMSA being consulted routinely to make sure that we weren't going to agree to any provisions that conflicted with PHMSA regulations. But nonetheless, there are provisions that go above and beyond, don't conflict with PHMSA regulations. In any event, the preemption that we're relying on in this case doesn't apply to other federal agencies. So there was no problem with EPA imposing these above and beyond requirements in a few areas. Likewise, we consult with the Coast Guard. We've consulted with the Coast Guard at length about anchor strikes. We're not saying that that somehow PHMSA displaces that possibility. So yes, other federal agencies can be involved. The state, unfortunately for the state, but fortunately for the functioning of the national pipeline network, can't be involved. And my last point, Your Honor, is that I don't think, with all due respect to this court, I don't think you want to get into the morass of setting yourself up as a overseer of PHMSA. If the state has concerns about the way PHMSA carries out its responsibility, the state can talk to PHMSA. The governor can call up and talk to the administrator of PHMSA. Those communications can exist, and in fact, PHMSA is open to communications from states. It's in their regulations. If the state has a concern about safety, what should the state do if it has a concern? It shouldn't turn a blind eye. It should let PHMSA know so that PHMSA can deal with it. So we have one regulator speaking with one voice. That's the only way the national network can operate, because these pipelines cross so many different political boundaries. I think those are the key points I want to make. I know the hour is late, and so
Thank you.
I think I'm done. Unless of course you have questions, Your Honor.
No, thank you, Mr. Coburn. Mr. Hassler, getting back to the ILI issue and your comment that it would take weeks to analyze the data. And perhaps this is not within the area you have been educated on by the engineers, but I'll ask this question anyway, and you tell me if it is or not. The way an ILI is conducted and the data retrieved allow Enbridge to go to a particular location. In other words, if Enbridge runs an ILI, and rather than analyzing data for weeks, which Enbridge may want to do, just as its belt and suspenders approach, as you've said, but as to the particular issue of this location that Enbridge essentially has concluded is not a concerning strike on the line, can that data be identified fairly quickly?
Your Honor, I have done my best to be a integrity whisperer today. I think, though, we've probably reached the limits of where I can provide useful and accurate information. I probably shouldn't have said it will take weeks for this reason, that in my experience with other ILIs on other lines, that's been the case. I probably should have answered that I need to go back to Enbridge and ask people who actually know, and we would ask the same question you raised. I just don't know the answer to whether you can focus in on one spot more quickly, but I assume Your Honor would like us to find that out. I mean,
I can't guarantee to you, Mr. Hassler, that it'll be determinative of anything I do one way or another with regard to this particular motion. But if it is an easy enough answer to find out, yes, if you could.
yes, Your Honor. And should we communicate that? I'm trying to think the best way.
Just send whatever information you have to Ms. Smith, along with a copy to Mr. Bach and Mr. Reichel, and that will suffice. Just
Of
by
course.
an email communication.
Of course, Your Honor.
Is there anything else anyone wants to tell me that we haven't already covered? I hear nothing.
Judge, I'm sorry to do this. Just two things. First, Mr. Hassler suggested, when I was arguing what seemed reasonable.
Mr. Reichel, hold on a second. You broke up there and I didn't catch what you just said.
I'm sorry. When Mr. Hassler suggested that our argument was based simply on what I personally thought was reasonable, I may have said it doesn't strike me as reasonable. But to be clear, I think the relevant inquiry is not my personal judgment. It sounded like that, that's not what I'm saying. I think the relevant inquiry is what is objectively reasonable, what a reasonable person looking at this from the outside would conclude. And the last point I want to make is something that Mr. Coburn said a moment ago. Perhaps I misunderstood it, but it seemed rather alarming. He seemed to say something to the effect that the due care obligation of the easement could only survive to the extent that it was consistent with current PHMSA regulations. We can brief that if we want to, but that seems to me a remarkable proposition. One can debate, the relationship between Enbridge's contractual obligations to the state and state law, but hopefully Mr. Coburn didn't mean to suggest that the federal government can essentially determine or revoke Enbridge's obligations to the state under the easement. If he's arguing that, I submit that's manifestly untrue.
Can I respond, Your Honor?
Coburn.
What I'm saying is that to the extent the state is interpreting the due care provision to give the state regulatory responsibility parallel to the responsibility that PHMSA has, such as Mr. Reichel has described. In other words, responsibility to determine if a reasonably prudent person would operate our pipeline, then he is overreaching in terms of his interpretation of the due care provision. The due care provision means, in our view, that we, as I've said before, I think I'm repeating myself, that we have an obligation to operate the pipeline consistent with PHMSA regulations. That's what it means. And to the extent it means more, to the extent it means the state becomes a regulator, as Mr. Reichel is asserting it can and does, we think that's preemptive. That's all I'm saying. I don't think that's new or different from anything we've said in this case generally about the state's regulatory role, which it doesn't have.
Anything further?
No, Your Honor. I think we've made our position clear.
All right, Mr. Hassler, anything further?
No, Your Honor.
Okay, very good. Well, in order to give this due consideration, which I think both parties want me to do, I will review this issue. I'll issue an order I will do so keeping in mind the urgency that everyone has tried to impress upon me as to the impact of having the line, at least the west line, shut down. The east line seems to be at least temporarily shut down, irrespective of what I might think. I will try to address that in the order as well, though, but because the preliminary injunction motion does address both, so I think it's proper for me to address both. But I will get something to you in writing, Mr. Hessler. As I said before, I can't guarantee that this is going to have any particular impact on what I may decide to do, but if you're able to get that information, it would be appreciated.
I will do my best, Your Honor, and we'll try to have you something tomorrow.
Very good. Thank you all. That concludes this hearing at this point.
Thank you, Your Honor.
Thank you, Your Honor.